Item number 15 of today's admission, that suspension. An indication was made that leave it to your lordship for update. Item number 15.
Yeah, can you hear me now?
Yes.
Yes, thank you. There's something new we have put in
Yes.
instead of these tall things.
It's more clear.
It's thank you. Yes, tell me.
Item number 15, the
That is
tasteful
for
matter.
upgrading, no?
Just a prayer.
Yes. Okay. We'll take it up at 2 after his matter.
Yes, after Mr. Company.
Here I am filing my affidavits in all matters. So I may be allowed to call on record. Oblige Lordship.
Please, Lordship, I beg to mention a WPC matter for listing, Lordship, along with the other two WPC matters. Both other two matters are both the pension matters. They have come in the list for tomorrow, Lordship.
Right? Why tomorrow?
This is urgent, Lordship. The petitioner is not receiving gratuity, leave and placement. Pension matter.
Tomorrow, that is next to impossible thing. He has retired?
Yes,
When?
31 December 2022.
22. Oh, can you read? What has happened? Any affidavits have been filed?
No, Lordship, it was last posted on 27/4/2020, but the item was scraped over.
Didn't reach. And what was my order then? Did it come on in pursuance to an order passed by me earlier?
Earlier, yes, the notice of issue, Lordship. And
Notice of motion I had issued?
yes, Lordship, and steps have been taken.
And what did I ask for on the last occasion?
Lordship for instructions, Lordship.
Instructions. Then we'll have it on 17th of May.
Not list.
Yes, where is the Government Council for the Social Welfare? Huh? Let's wait for 10 minutes.
And number 2.
Lordship, pass over to the matter for time being.
Why?
My senior is mentioning the case, Your Lordship, in other court. He will be coming.
What is the matter about? There are a lot of people who are waiting in the queue for doing the matters. So, if you want the matter to be taken up, then you have to be, matter has to be taken. What are you asking for? To set aside the order passed by the Director of Agriculture, pay the area wages, salaries of the petitioner with effect from so and so, to pay the current wages on regular basis. What is this order of 16.8? Yes, Madam Bora. Just put on that thing.
Lordship, I have a small pair. This matter has been handled by Ms. R. Bora. She has some personal difficulty because of the Saddha ceremonies at home, Lordship. So, matter may be any other date, Lordship.
Okay, we'll take it up on some other day.
Lordship, highly obliged.
Yes, heard this.
Elmar, Your
So and so, the learned counsel for the petitioner, Ms. So and so appears on behalf of the Agriculture Department, who submits that the matter is being handled by Ms.
R. Bora.
R. Bora, who on account of the personal difficulties could not attend the court today. Taking into account the same, list this matter again on 23rd of May 2023.
Highly obliged.
At number 3 to 13.
That will be a 2. So write it down. Yeah,
And number 14.
14.
Made to your lordship. My lord, I have filed my affidavit, my lord. But ACC is yet to file the affidavit. Department has filed. Transport has filed that.
Would that matter?
My lord, the pension matter.
1970.
My lord. They are not entitled for pension, my lord. So for my affidavit is concerned.
You have filed. The
My
response
lord.
number 1 has
My
filed.
lord, my lord.
Is the state filing it?
Yes, I'm the
State
transport
is represented by Mr. H. Sharma.
lordship. Here I am the transport department. I have filed.
Okay, okay, you are appealing. That
ASTC.
ASTC has not filed. Where
Yes.
is Mr. C. Sharma?
RM,
You
that
were
is the
supposed
selling
to
council.
file. Okay, none appears on behalf of the petitioner on call. Ms. M. D. Bora, the learned counsel, is appearing for the
Transport department.
Transport Department, submits that the Transport Department has already filed their affidavit on 3/5/2023.
Right.
However, it appears that the ASTC have not filed their affidavit. Taking into account that the petitioner is not represented, as well as the counsel appearing on behalf of the ASTC. Apart from the fact that the ASTC has not filed their affidavit, this is the matter again on 29th of May 2023. The ASTC is given the final chance to file their affidavits in the matter.
I'm deeply obliged.
16.
Why is this matter listed today? They are asking for provincialization, this areas, Mr. Sharma.
Yeah, and they are under BTC lordship.
Oh. Okay, none appears on behalf of the petitioner on call. As well as also none appears on behalf of the BTC. Taking into account the same. Again listed on 5th of June 2023.
Here I appear for finance department.
Mr. P. N. Sharma appears for the
Elementary lordship.
Elementary Education Department, and Mr. R. Bopujari appears for the finance. Do you have any instructions? No instructions.
No,
And number 17 for orders.
Yes,
Your
ma'am.
lordship, we have filed additional affidavit for
Oh, that's
for
right.
the state service lordship.
You have filed your additional
Yes,
affidavit?
lordship. We have filed.
Okay. Yes, tell me.
Additional
What
affidavit
is
for
your
the
case?
lordship,
lordship may take up the indeliminate application first. Lordship.
IA is their lordship.
For what?
We have filed the interlocutory application for vacating of modification of the interim order lordship.
What interim model?
The lordship may take up the interlocutory application lordship, IA.
Therefore, we do not find any prime official reason why the petitioner has been paid, not
Say-
been paid. Accordingly, in the interim,
Lordship.
he is directed to pay the salary and allowance to the petitioner. It will remain open to the respondent to the take a note. Which school the petitioner will serve in the, if so and so creates any obstacle to the petitioner in discharging the duty, the respondents to the area shall take appropriate measures, including providing security to the petitioner for the purpose of discharging duty. Yes. Mr. Bora, you didn't appear in the earlier matter pertaining to BTC. The BTC council,
16, item 37.
I'm sorry, my lord.
you are not filing the affidavit,
No, I have not yet. I'm waiting for the instruction.
you have no instruction. We are taking it on 5th of June. Get your affidavit, file your affidavit. Yes, you have filed an IA for vacating.
Lordship.
What is the reason?
Lordship, the interim order has been obtained by suppressing some facts, Lordship.
Oh,
Lordship may take up the interlocutory application. Paragraph number 4, Lordship.
was released from so and so to enable him to join in Uttar Pradesh where he sought to transfer to. He simply submitted a joining report on so and so to his new school, but did not report for his work thereafter. So that is your case.
Lordship, although he submitted the joining report, but never reported for duty, Lordship. Although he submitted joining
Now,
report.
what is the case of the petitioner hearing? Have you filed your affidavit, madam?
No, Lordship.
Why? You don't want to file an affidavit?
We need some time to file a reply. letter. We
Lordship,
need
they
some
have,
time. No, we did not
they
file.
have filed a writ petition and they obtained the interim order. We have filed.
This
our-
was filed,
filed
this
it, yeah.
application, this IA was filed in the year 2022.
Lordship,
Until now, you have not filed your reply. Matter has come up on various occasions
no, Lordship, they have filed. They have filed objection.
Lordship.
They have filed objection, Lordship,
in this matter.
in this interlocutory.
Okay, what do they say on that? Let us see what is this petition about. What are you asking in the petition? Directing the respondents to release the current salary of a petitioner from July 2018 till date and also area salary which is pending to your petitioner as she is working till date in so and so and so you want the current salaries
Yes, Lordship.
from July 2018 till date
Yes, Lordship.
as well as the area salary which period?
Period, Lordship.
Oh, you're not ready?
No, Lordship.
Yeah.
And in the writ petition also, we have filed our affidavit, Lordship.
Now, are you paying the presently paying the salary to the petitioner?
No, Lordship.
No. Yes, madam.
Petitioner's salary has been stopped.
Has been stopped since
15 July 2018.
18.
And what?
So your claim in the writ petition pertains to the period after 15th of July 2018.
18, my God.
Why the salary has been stopped?
The petitioner and the respondent number 8, they were entered into a mutual understanding that for their transfer to each other place, and accordingly they applied for mutual transfer in the year of 2016. But that transfer order was kept by the government. But at the time of initial approach for mutual transfer, the petitioner handed over the 3 numbers of copies with duly signed by him to the respondent number 6 on good faith. Later on, on 2016, when the earlier
first approach was for mutual transfer order was cancelled by the government. Again, the respondent number 8, who has submitted the application for mutual transfer of the petitioner and in between the petitioner and the respondent number 6, and submitted the copy before the respondent authority. Accordingly, the mutual transfer order was issued. Although the sign of the petitioner was there, petitioner was complied with the order of transfer, and accordingly he joined in the transfer post of where he was transferred the Uttar Panpara school under the same block. But the respondent number 6 also joined 2 times, my lord. Hereafter, the petitioner was not permitted to work in the newly transferred school, and again he has submitted. Again he come to his earlier school, my lord, and managing committee of the school and the president, managing committee, and the local people of the school organized a meeting and submitted a representation before the director to inquire the matter. And director forwarded the letter to the commissioner and secretary, and commissioner and secretary directed to inquiry about the matter. An inquiry was initiated by the competent authority, and the result and report was there. That is on Annexure 23, page 84, madam. In compliance of the government order number so and so.
So, madam, here on there was a mutual transfer in the year 2016.
16. That was
Now
cancelled.
that was cancelled. Thereafter, there is again a mutual transfer order on 26/6/2018.
Yes, madam. But
Now that mutual transfer, pursuant to that, you were released from 1125 Daksin
Daksin
Kaljar Lower Primary School.
Lower Primary School.
Then you submitted the joining report on 2/7/2018
18.
in that 1125.
Yes.
No, I don't understood. The release order of the petitioner from 1125 was given. Then you joined in Uttar Panpara Lower Primary School on 2/7/2018.
Yes, madam.
Then the respondent number 10 submitted her joining report in so and so on 36/2018 prior to you.
Prior to. And we
Okay.
have
Then
submitted
the respondent again submitted her joining report at 1124 twice.
twice, my.
Okay, fantastic. Then the prayer petition submitted by the president of SMC of Dakhin Khaljar LP School.
That is earlier school.
Yes, 1125.
Yes, my.
Relating to?
Relating to that, he was not permitted to perform his duties the newly transferred school, that is Uttar Panpara school, and accordingly the respondent number 6.
So this representation was submitted by a school where you were previously
Yes,
working.
yes, my.
But you were already released.
Yes, my.
So this representation has no meaning.
Meaning.
Okay, then the
petitioner
secretary to the
submit-
government of Assam forwarded the representation. Letter issued by the Director of Education regarding mutual transfer on 2/6/2018. Submitted a representation before year. What was this for cancellation of that order of transfer?
Yes.
From 1125 to this this Panpara LP school. You wanted the cancellation of the transfer order.
Yes, my.
The in charge block so and so issued a letter to the petitioner directing to explain for not handing over the necessary papers to the respondent number 1.
So called.
Okay, which papers? Papers pertaining to 1125.
Yes, my.
Okay, petitioner submitted his reply. The director of elementary education issued a letter to the commissioner and secretary requesting to solve the issue relating to online virtual transfer of the petitioner and the respondent. Joint secretary to so and so issued a letter to the director directing to inquire the matter of mutual transfer of so and so. The report submitted by in charge so and so. What is this report? Huh? What is Annexure 17?
Annexure 17 is a report, my lord.
Page
uh, that is on page 68.
29/9/2018.
Yes, my lord.
This report is to the sir during inquiry it is learned that the majority of the people of that area is not allowing the headmaster to go away from that school, and that is why he is still working in that school. Who is this person?
That is the petitioner.
Mantos Mondak.
Mantos Modak.
In which school? 1125.
1125, earlier school.
But you have been released.
Yes, but
But
there,
how you released and joined somewhere else?
Yes.
Then how can you be still working in that school in 1125?
no, my lord, what is that after joining in the newly transferred school, my lord, that school did not allow the petitioner to work. That is why he was nowhere.
Understood. But then how could you have joined it unless that order of
Yes,
transfer is cancelled?
I could not join my.
But why is it mentioned in this inquiry report of 29/9/2018 that during inquiry it is learned that the majority of the people of that area is not allowing the headmaster Mantos Mondok to go away from the school. That is why he is still working in that school. How can you work in 1125 if the transfer order has already been given effect to?
That is the upon the headmaster, then upon headmaster, how he has.
Understood, but you have no right to
Right.
remain in that school
Actually, my lord, what
after
happened
you
is
have been released.
he was nowhere, either in this earlier school nor present school, where he was transferred. So although he was not working on the, not permitted to work in the newly transferred school, and he again back to his original school, but he has already released from that school.
1125.
Yes.
Yes, you have
They are
already been released.
but the
And the respondent number 10 has already joined.
joined, my lord.
So
But
under such
respondent number
circumstances,
10
where are you
has been
working?
joined, my lord.
I know in the education department it keeps on happening.
It's here.
That
Yes,
how many teachers is immaterial, how many appointments
Many
is
teachers.
immaterial. People can very well go there and then stuck.
But I don't know why he was performing his duty his earlier school, and headmaster and the managing committee is allowed to do work.
Now
That is-
thereafter what happened?
The government employee can submit an inquiry report, my lord, page number 17. The report says that how a government employee can submit two joining report on different dates in her place of work. It is therefore requested directly.
Issued a letter issued by DEO Borpeta directing the petitioner to hand over the charge to assistant teacher. Now this letter at annexure 18, whereas Minal assistant
Minal Kanti assume charge the head teacher of the said school.
Allowed to assume charge of the head teacher. Not
Minal Kanta is who? He's another person.
another teacher of 1125.
So he has been asked to use here. Okay, then
Then my lord, an office order
and what
was
is the name of the petitioner?
Mantos Medok.
Medok. Okay, then the office so and so is hereby cancelled. Now what is this order? 11/10/2018.
11/10/2018.
Kishore Rajvamshi is allowed to take over the charge of head teacher of so and so. He is also here. So this was cancelled.
This was
Annexure 18 was cancelled by Annexure 19. Yes.
And on 13 November
Annexure
2009,
18 was cancelled by Annexure 19. Then comes 13 November to the Secretary online mutual transfer of Srimati Rohima Khatun and so regarding that is on 13th of November 2008.
here was the inquiry report on page 76, 21.
To find out the fact regarding the online transfer of so and so. The employer had submitted the inquiry after conducting hearing from both the parties along the request. Stated that she will the High Court, and the High Court has passed to maintain whether it will release the current salary of the petitioner if rendering service by order dated March. Now, what does the inquiry report say after going to the statement submitted by Iman and so, agents of so and considering the delay in execution of the transfer order, the above mentioned transfer order may be cancelled in respect of so, the greater interest of the owner.
from inquiry, it is revealed that
Then,
for the second
then
time, the
comes
petitioner.
another case by which filed by him, filed by respondent number 10.
10, my lord.
Directing the respondent to resolve the issue by passing appropriate order after affording opportunity to both the petitioner and respondent as regard their respective claims. The respondent director will also consider and examine the claim of the petitioner and respondent as regard non-payment of salary, so and so. Then, in compliance to the order dated so and so.
Respondent
Who
number,
is put under suspension? In
The
case of
respondent number 10.
question under
For me,
money, we are
for
placed under
fraudulently
suspension.
make the,
For fraudulent, madam, this document page 23, I don't know, how can you read it? I can't read it. Read it.
in compliance of the
No,
above
no, no,
order
no, no.
number so
Huh?
and so,
This is not
and
possible.
pending Dorel of departmental proceeding is Rahima Khatun, assistant teacher of Uttar Kanpara LP school under BPO Jala in Barbeta district, who joined in
Presently joined.
presently joined in 1125 number of Dakshin Kaljar LP school
This
in
is
place of
pertaining
Sri
to the
Montus
respondent number 10
Madam,
also.
assistant
Under
teacher
suspended
Bhavani
with
Kaur,
immediate effect as if fraudulently, then what is that letter? What is that line thereafter?
fraudulently try to make
Anyway, respondent number 10 was put under suspension.
suspension, my lord.
Now, tell me what has happened to that original order of transfer? And when there is already an order by Justice Koteshwar Singh,
To pay the salary,
what have you done?
but till date nothing
Pursuant to Justice Koteshwar Singh's judgment order,
order dated
kindly come to page 81
6/12.
and more particularly at page 82. Accordingly, the repetition stands disposed of.
This is in relation to the respondent number 10.
No, no, no.
No.
Respondent number 7, I think, is the petitioner here. Respondent number 7 is the petitioner.
Having heard the counsel of the parties according to the decision disposed by directing the Director of Assam to resolve the issue by passing appropriate order after offering due opportunity. There was a hearing, Lordship.
Where? What happened thereafter?
As regards the response director of Assam will also consider the examined. Lordship may take up my affidavit, Lordship.
Yes, tell me.
With regard to the statement, paragraph number 7, with regard to the statement made in paragraph 4 of the written answer, the petitioner and the respondent number 10, Srimati so-and-so, teacher of Uttar Panpara LP school under block so-and-so, had applied for online mutual transfer so-and-so, and the office of the answering department had issued mutual transfer order in respect of right order number 26/6/2018. Hence, the claim of the petitioner regarding ignorance about the submission of the online business. With regard to the enable him to join the paragraph number 9, Lordship. After receiving the mutual transfer order, so and so issued by the office of the answering deponent, the respondent number 10, Srimati Rahima Khatun, joined in 1125, which was accepted by the president of 1125, the managing committee of the school, and had then submitted a prayer petition before the commissioner secretary of the government of Assam Elementary Education Department on 2/7/2018, praying for cancellation of the transfer order dated so and so, and the government forwarded the same later dated so and so.
So there is a so-called notice issued to the petitioner on
Lordship,
4/9/2021
Lordship,
for not attending.
for not attending and not handing over the charge from that one.
No, Mr. Counsel, you have not read the file. Kindly come to page annexure 1, page 10 of your.
Lordship, 4/9/2021.
This is a different. That one which you are referring was for those documents.
Lord.
That is in 2018.
You are hereby asked to show us why the disciplinary action under
After your release from the state school, you have not handed over the charge of HT of the state school for
Lord,
which the DO had issued an order to
Lordship.
denounce so and so, who allowed the so and so, and the DO has also asked you to join to your new place of posting at so and so. Again, you have not joined. So
No.
the DO has asked to show cause for not joining at the new place of posting after releasing from so and so as per the mutual transfer order dated so and so.
Yes, sir.
In spite of several instructions, you have not followed the order.
Government order.
Yes, madam, what have you done to this so called?
Because he has filed a reply by the,
Then what happened?
yeah, so nothing has been done. In
Now,
the
I understand whatever
in
may
the-
be, but where is the petitioner now?
In the,
Petitioner is there in Panpari or 1125?
No, she has not reported for.
No, but as of now, where are you? You are initiating a departmental proceedings against the petitioner.
Lordship.
As what?
Based on Pampara school, Lordship. The subsequently transferred school.
Hmm?
Subsequently, where the petitioner was transferred.
So, as of now, as per you, the petitioner is there in this Panpari.
Panpari. Although she had never
It's
reported
a
for
different
it.
thing.
Lord.
But the petitioner is there in Panpari.
Lordship, Lordship.
Chalo. So, as of now, but what have you done to the order passed by Justice Koteshwar Singh? There is no reply to that.
Lordship.
More particularly, it is annexure. What is the date of this order? 4/12/2019. This is pursuant to,
Page number,
after
Lordship.
this, you have issued this so called,
Page number, Lordship.
yes, page 81 of the writ petition.
Of the writ petition.
What have you done?
Let me check.
Now, in pursuance to this, you had the hold the inquiry,
Lordship.
and in the inquiry, there is a request for.
Page 81 is the order dated 6/12/2019. 6/12/2019. Order dated.
Yes.
yes.
So pursuant to that, this inquiry report was there, wherein I think this is inquiry report. You find it here. Here. This inquiry report is dated what?
6 February 2020.
Inquiry report dated. Yes, 6/12. Oh, this is
Earlier.
okay. Prior to that, this inquiry was preceded by that order.
By that.
So thereafter, what have you done? What compliance have you resorted to at page 82? Anything, madam? Anything has happened?
As per my information, petitioner is now after inquiry, the petitioner is no longer in service because he is not permitted to work either.
He is not in service or he is not permitted to work?
Not in service, not my lord. He is not permitted to do this work in the earlier school or the present school. He is sitting idle, my lord.
It is not that not permitted, Lordship. The petitioner did not report.
No, my lord. Petitioner each and
In
every
spite
day.
of
Okay.
serving the
Now,
joining report.
let us see the order passed by Justice Budol Burua, more particularly at paragraph number 8, which you are asking for vacating.
Lordship.
In the aforesaid circumstances, we do not find any prima facie reason as to why the petitioner has not been paid the salary and allowances. Accordingly, in the interim, it is directed the respondents to pay the salary and allowance to the petitioner. It will be open to the respondents to take note of as to in which school the petitioner will serve in either of the two schools. If Uttar so-and-so Dala creates any obstacle to the petitioner in discharging duty, the respondents to the so-and-so shall take appropriate steps for providing security. Now, what have you done?
Lordship, there is no question of security. The petitioner has never been prevented from joining the duty, Lordship. The petitioner intentionally did not
No,
join.
my lord. That is not.
Understood. That is
Lordship.
for the purpose of salary, we'll take a call on that.
Lordship.
But what have you done in regard to this? Madam, have you submitted this order to the headmaster?
Yes, my lord.
When?
After receiving the
Where is
clarified
that?
copy.
Well, that is a very
Petition-
vital thing that
the
you have gone
petitioner-
there to join.
Petitioner has submitted the.
When
copy.
do you, where have you mentioned? Because that is a very important thing. Because now you are saying that petitioner is nowhere, that in spite of there being an order being passed by the court, if the director of elementary education have not allowed them, then the orders passed by court had been made a mockery.
The petitioner has submitted the copy before the director.
No, I'm not concerned with the director. Have you gone there to the school to join thereafter?
I have
After
to
with
take
this order?
There is
I have to
no
take
risk.
instruction, my.
Huh?
I have to take instruction on which date he has submitted the copy of the order. The date. He has reportedly.
And if you have not done, then
No, my lord. He has reportedly informed me that I have eventually time and again visited the school.
then why haven't you put it on affidavit? That aspect of the matter.
I will
When
file
you
it.
put no in your reply, this order pursuant to this order they have filed the affidavit.
Yes.
And after that you have filed your reply.
I am not filing.
There's no reply.
There is objection in the IA.
You have filed an additional affidavit. You have filed an additional affidavit of justice or no? Not that. But anyway, you have filed an objection.
Objection
Yes.
for
Now in the objection, have you mentioned that you have gone there to join? And they have not allowed you to join?
and even the joining letter is also not annexed. If
Joining
at all
letter I have.
petitioner has done.
I have the joining letter but I did not annex. When the petitioner submitted the joining
No,
letter.
my question specific to you is pursuant to this order of 24/9/2021, have you submitted this order before the headmaster
Yes.
of the school for joining? As well as also to the director of elementary education allowing to providing you the security if you are not being allowed to join? First of all, you have to join. Have you joined there?
No, he was not permitted to join. madam.
When? After 24/9?
Yes, my lord.
Where is your statement? Where is your statement that you went out there to join, but you were not allowed to join? Show me that. Don't make statements just on the thin air out there. Hey, you was done this, you was not done that. Because these are statements which are required to be made on affidavit. And you filed your affidavit against the IA, but you have not mentioned that. Have you mentioned, Mr. Sharma?
No, Lordship.
Then-
I have not come across, Lordship.
Then
Even on the.
Then why are you entitled to the salary if you have not joined? First and foremost, how can you be entitled to the salary? More particularly after this order of 24/9, if you have not cared to join out there in the school. And thereafter, if you have not been allowed to join, have you asked for any protection from the director of elementary education for that?
But from a daily
If you have
attendance.
not done, then what case you have?
My lord, daily attendance I have annexed the attendance register. The
Where?
form-
Of which school? Don't tell me you have gone out there to 1125.
Good report shows that the petitioner is in service, my lord.
Because their specific submission is,
Yes.
Casey, that from 27/2018, you have never set your foot out there after giving the joining report. Isn't it, Mr. Sharma?
Lordship.
Then,
No, my
We
lord.
have clearly mentioned in our affidavit as well.
and that too in more particularly in paragraph 4 of their application. You have filed a reply. What is your contents of your reply to paragraph 4? Let's see. Where is the objection file? Yes, long. The objection is bigger than the petition.
Yes, my lord, I have stated in paragraph 4.
Paragraph 3.
prepare.
So and so did not hand over the charge. They mentioned the headmistress of so and so in the event did not hand over the charge on she permitted him to join the school on demand to enable him to join in so and so. The allegation made in Mia he did not report to her after joining in the is totally false because the respondent number 10 in the revision was the mistress of so and so did not hand over the charge of the school. You were transferred as a head teacher or assistant teacher?
Assistant.
Then, well, how does the question of the headmistress of so and so did not hand over the charge of the school? These are all, you have said all these things after. Nice code and all. No, you have not mentioned anything. After this order, you have been there. Then your intention is clear.
No, my lord, I
It is
have,
not bona fide.
It is
no,
not
my
bona
lord, I
fide.
have filed a
This is what we have
certified
stated,
copy
Lord.
of the order. Let me some time, I will file a
No,
affidavit.
no, did you go there to join thereafter?
He has,
Madam, are you saying by yourself or is it mean any form of affidavit or anything? Nothing is there.
I will file affidavit, my lord.
Why are
Sorry,
you
my
going to
lord.
file now? We should dismiss your petition.
No, my lord.
Yes.
No, my
How
lord.
are you entitled for? First of all, why are you working after handing over the charge on 1125? How can you be entitled to this?
No, I am not entitled, but they
Then,
are, I
then
have,
why are you asking for the salary from July 2018?
yes, I have asking for
Understood.
salary
From
for July 2000.
2021 onward, 21 order thereafter, if you have joined out there, you are entitled for a salary. But why earlier period and what has happened to the departmental proceedings? You have filed, submitted a reply on 13/9/2021. And what have you done pursuant to Justice Koteshwar Singh's order?
That instruction I will obtain, Lord, sir. Subsequent development in the inquiry.
Lordship, I will file an affidavit because
Lord-
he has submitted the joining report before
Not
the.
only that, pursuant to the affidavit order, you have joined out there, you have taken, applied before the headmistress for joining, and either you have joined, which as per them you have not joined, and pursuant to that, if you are not, have you reported the fact to the Director of Elementary Education? Because there is a direction to the Director of Elementary Education
has
about this thing.
He has submitted the
No.
certified
First
copy
you
of
have
the
to
order.
join the
Certified and
Ms. A. Buzarguru, the learned counsel for the petitioner. I've also heard Mr. P. N. Sharma, the learned counsel, appearing on behalf of the Elementary Education Department. You are?
That's one number 10 years.
Yes. What happened to that order of Justice Koteshwar Singh?
Person to that there was a proceeding against me. Thereafter, again, I was regularized here, Your Honor. And now I am retired from the service, and my that one is also pension is also regularized.
You are getting pension
Your Honor.
from
From
1125.
Yes, I was drawing salary from there. I got retired from that school. Your Honor.
So and so appears for the respondent number 10. Court, upon hearing the matter, put a specific query upon the learned counsel for the petitioner as to whether the petitioner, in pursuance to the order dated 24/9/2021, had they taken any steps for joining in the Uttar Palpara LP school.
Yes.
Jala Education Board block. In as much as the transfer order dated, what is that order of transfer dated?
26/6/2018.
26/6/2018.
26/6/2018.
So and so was still operational. although an affidavit has been filed in as an objection to the interlocutory application so filed by the Elementary Education Department for vacating the order dated 24/9/2021. But a perusal of the entire affidavit does not disclose that in pursuance to the order dated 24/9/2021, the petitioner had visited the said school, that is Uttar Panpara LP School. It further does not transpire from the materials on record that the petitioner was not allowed thereafter to join pursuant to the order dated 24/9/2021, or the petitioner had reported the fact to the Director of Elementary Education. Ms. A. Buzarbulwa, the learned counsel for the petitioner, submits that she would take necessary instructions in that regard and file an affidavit. This court also inquired with the learned counsel appearing on behalf of the Elementary Education Department as to what happened pursuant to the order dated
4/9/2021.
6/12/2019 in WPC number 2722/2019, wherein this court had categorically directed the Director of Elementary Education assigned to resolve the issue by passing appropriate orders by considering the respective claims of the petitioner herein as well as the respondent number 10 here, petitioner as well as the respondent number 10 herein. Mr. P.N. Sharma, the learned counsel, further submits. Further to that, this court also inquired with the learned counsel as to what has happened to the departmental proceedings which was initiated against the petitioner, and as to whether the petitioner has been put under suspension. The learned counsel for the Elementary Education Department submitted that he will take necessary instructions in that regard. Mr. So-and-so, appearing for the respondent number 10, submitted that although the respondent number 10, pursuant to the order dated 6/12/2019 in WPC number 2722/2019, was suspended, but thereafter the said suspension was withdrawn. And in the meantime, and pursuant thereto, the respondent number 10 have also retired and is presently getting her regular pension. You're getting pension?
Some area is there, but getting the pension.
You are getting a regular pension or not?
I have to seek instruction.
I've already retired. Be that as it may, this court fixes this matter again on when
I cannot.
Hmm?
23rd May.
fixes the matter again on. Is this a pension? No, salary, area salary. Fixes this matter again on 24th of May 2023. On which date the learned counsel for the petitioner shall file the affidavit, if so advised, and Mr. P.N. Sharma, the learned counsel for the Elementary Education Department, shall also obtain the necessary instructions in that regard. Full stop. Taking into account the specific stands which have been taken by the respondent department, this court is of the opinion that the interest of justice would be met if the order dated 24/9/2021 passed in in the instant writ petition insofar as the direction to release the salary of the petitioner, area salary of the petitioner is kept in abeyance till the next date.
Eighteen,
But the remaining part of the order remains. Lordship. Yes, review petition.
Yes.
What is this? Sometimes you are appearing, he is not. He is appearing, you are not.
On
Then-
on last occasion, my lord, I was absent because, in fact, I was present in the court, but
You left.
I left because I'm not aware.
D. Musari was there to come to your aid.
I'm not aware of, because my name was not shown. That's why I missed the item, my
But
lord.
you were not aware because your name was not shown.
Yes, sir.
But she was much aware that you were there and as such
Yes,
to seek for an accommodation.
In fact,
So you have to understand which way you want. So here the petitioner is not here. What to do?
I have filed my affidavit, my lord.
We'll take your matter after some time. Yes, Mr. Dasgupta, your matter. That is the item number 1. Because these people have forgotten. Yes, have you got it?
Lordship, there was a scheme, Lordship,
Yes.
for pension, Lordship.
Scheme, what scheme is that? You have got it?
Lordship, I've got that. The Shohid Kushal Kumar Harbojanin Vridha Pension Asani.
How does one get it?
That Lordship has to apply, Lordship.
Apply how?
How, Lordship, the form was attached to that scheme, Lordship. Before the Deputy Commissioner, Lordship, has it. The scheme is given, Lordship.
Now, what is the criteria?
Lordship,
Mr. Dasgupta, you have been given a copy of it?
Lordship.
Give a copy to Mr. Dasgupta. Read what are the requisites?
Lordship, কমেও 60 বছৰ পূৰ্ণ হ'ব লাগিব।
That is
Six qualified. বৰ্তমান চলি থকা কোনো চৰকাৰী আঁচনি পেঞ্চন আঁচনিত অনুভুক্ত হ'ব নালাগিব।
She is not getting
50,000 বা তাতকে কম দৰমহা পোৱা চাকৰি কৰ্মচাৰীৰ পিতৃ মাতৃ এই পেঞ্চনৰ বাবে যোগ্য।
What is that?
50,000 less.
50,000 বা তাতকৈ কম দৰমহা প্ৰাপ্ত চৰকাৰী কৰ্মচাৰীৰ পিতৃ মাতৃ their children should not draw salary more than 50,000 if they are to be entitled. The parents are to be entitled.
No, she doesn't have children, so that doesn't have. Okay.
বছৰি 2.5 লাখৰ বেছি আয় থকা লোক এই পেঞ্চনৰ বাবে বিবেচিত
She
নহয়।
doesn't have. You don't
So
have.
he fulfills the criteria.
So this she will get.
Yes.
Then you do one thing. Who is that? To whom this is to be applied?
It is to the Deputy Commissioner, Lord,
Of
the district, Lord.
which district? Mr. Dasgupta, which district is this?
Kamrup.
Your
Kamrup.
case?
Kokrajat, Lord.
District will be
Kokrajat.
Kokrajhar. Okay. Chalo. So we dispose it of with the direction that you will submit this form out there. And the Deputy Commissioner Kokrajhar is here? No.
No.
Yes. You are there. You,
Lordship.
Mr. S.S. Roy,
Lordship.
you are there. So we make you the Deputy Commissioner Kokrajhar a party.
Lordship.
And then you accept notice, then we pass the order down.
Lordship.
Heard Mr. A. Dasgupta, the learned senior counsel, assisted by so and so. Mr. S.S. Roy appears on behalf of the respondent number
1 and 6.
1 and 6. Mr. P.N. Sharma appears on behalf of respondent number two.
Only Lord.
Two.
Lordship. The PTC completed.
Two. Mr. S. Bora. He was there, I saw it somewhere.
Yeah.
Mr. S. Bora appears on behalf of the respondent number three. And what is this? Assistant Director of Audit.
Audit.
Three. Mr. Arbo Pujari appears for respondent number four. Mr. A. Hassan appears for the respondent number five. Upon hearing the matter at length and taking into account that the services of the petitioner was not regularized during her entire career, although the petitioner was rendering her services in which school? In 775 number Fakira Gram Primary School since 10/8/1975. This court had on 2/5/2023 directed the council representing the Social Welfare Department to apprise this court as to whether the government of Assam has any pension scheme for aged persons who is not getting the benefit of service pension given by the government of Assam. Today, while hearing the matter, today when the matter was taken up, Mr. S.S. Roy, the learned counsel appearing on behalf of the Social Welfare Department, submitted that to cater to the need of those persons who are not getting the benefit of service pension by the government of Assam or any other state entities. The government of Assam had formulated a pension scheme known as the Sohit Kusal Kuor
Sarvajanin Bidya Pension Asani.
This court put a pointed query upon the learned counsel appearing for the Social Welfare Department as to which authority grants the say to whom the application is required to be made. The learned counsel appearing for the Social Welfare Department submitted that it will be the concerned deputy commissioner to whom the said application has to be made. In the instant case, it has been further submitted that for the purpose of the instant case, it is the deputy commissioner Karimganj, who shall be the authority to whom the application form has to be filled up, submitted. Taking into account that for passing an effective relief, the presence of the Deputy Commissioner Kokrajhar would be necessary. This court, in the interest of justice, includes the Deputy Commissioner Kokrajhar as the respondent number 7 to the instant proceedings. Seven to the instant proceedings. The registry shall make necessary changes in the records on the basis of the instant order. Mr. S.S. Roy, the learned counsel appearing for the Social Welfare Department, further submits that he can also accept notice on behalf of the respondent number, newly impleted respondent number 7. Next. That he accepts notice on behalf of the newly implemented respondent number 7. Next. In the backdrop of the above, let this court therefore take into account the further facts of the instant case. The petitioner herein was appointed as an honorary teacher of 775 number Fakiragram Primary School on 10/8/1975. However, the same school in question was provincialized on 1/1/1967. The petitioner filed a writ petition being WPC number 596/1995 after rendering more than 20 years after rendering around 20 years of service, claiming regularization. This court, by an order dated 16/12/1995, disposed of the writ petition, directing the concerned respondents to make an inquiry and pass necessary speaking orders within 4 months. Thereupon, as the respondent authorities did not take any action, the petitioner filed a contempt proceedings, initiated a contempt proceedings which was registered and numbered as COP/C number 663/1996. However, this court, by an order dated 7/5/1997, closed the contempt proceedings, taking note of the fact that as the petitioner was appointed after the provincialization, the benefit of the petitioner, the petitioner was after the provincialization of the school in question, no benefit as regards her appointment could be given to the petitioner. However, while closing the contempt proceedings, a rider was given that the authority may consider the misery of the petitioner inasmuch as the petitioner has put up service for more than 21 years. It further appears from records that the petitioner thereupon preferred a writ appeal against the order dated 7/5/1997 in COP/C number 663/1996. The said writ appeal was registered and numbered as WA number 157/2003. This court, by the division bench of this court, by an order dated 6/11/2006, disposed of the said writ appeal, directing the respondents to give preference to the petitioner in terms with the office memo dated 21/1/2004 in the form of relaxation of age only, as and when the question arises for filling up the vacancies through regular selection. However, nothing happened, and the petitioner in the meantime crossed her age of superannuation. It is under such circumstances that the petitioner has again approached this court by filing a writ petition, thereby directing the respondents to grant the petitioner an old age pension for her service to the cause of the children's education as contained under Article 41 and Article 39A of the Constitution of India. As already stated here in Supra, there is a pension scheme in the name and style of Sohit It further appears that there are certain requirements to be fulfilled for the purpose of being eligible for the said pension. Upon hearing the learned counsel for the parties, and taking into account the facts involved, this court is of the opinion that the petitioner is eligible in terms with the criteria mentioned in the eligibility criteria of the said pension scheme. However, for getting the benefit of the said pension scheme, it is required that the petitioner has to file an application before the in a particular format before the respondent number 7. The learned counsel senior counsel appearing on behalf of the petitioner submits that the petitioner shall do the needful in that regard. Accordingly, this court therefore disposes of the petition, thereby giving the liberty to the petitioner to submit the application in respect to the Sohit Kusal and so before the respondent number 7, who shall after making the required verification and taking the necessary particulars from the petitioner, shall process the application so that the petitioner gets the said pension in terms with the said scheme. Within a period of
8 weeks.
8 weeks from the date of application so submitted by the petitioner along with a certified copy of this order. The above the instant petition says. I think something good has come out.
Eighteen. Item 18.
Yes. Yeah, matter.
It's the lordship will take up at 2.
Or your review.
Oh, no.
No, none appears. None appears on behalf of the review petitioner on call. Mr. N.J. Khatani appears on behalf of the respondents. This matter was called for the second time today. Taking into account that the petitioner is not represented, that the matter be listed after 3 weeks.
Item 19 for hearing.
My lord, madam, passport for the time being. He's on legs, my lord. Mr. P.N. Goswami is in another court.
Huh?
Mr. P.N. Goswami is another court, my lord. Madam, passport for the time.
Matter pertains to what? Mr. Kutuki?
It relates to, my lord, granting revised pensionary benefit.
Revised?
Pensionary benefit.
Revised pensionary benefits.
Yes. Pay Commission submitted report and they accepted the Pay Commission report. They revised the pay scale, but deprived the petitioner from getting the revised benefit.
why is this matter before the division bench? Was this matter before the division bench? No. What is this?
No.
148/2017. Yes, you are ready to do. Because otherwise also, the order sheet has become fatter than the repetition. It doesn't look nice. Yes.
The petitioner was branch manager of the respondent bank. He retired
My
on
lord,
eight-
is on legs, madam. Madam, pass over for a time being, madam. I'm thinking for passing.
You see, I'm hearing him.
My lord.
You take your notes. Okay? And if you want, then if he completes, your senior does not come, then I'll start dictating. While dictating also, if your senior comes, I will hear. If your senior then also does not come, then I think he should directly go from there to court number 1 for filing an appeal. Yes.
The petitioner was branch manager of respondent bank. He retired from on attaining age of 60 on 31/12/2007.
To set aside the impugned clause 2 of the circular dated demand, whereby the petitioner was denied the benefit of revised pay 2000 by way of arrear as after hearing. So your prayer is that some clause 2 of the circular, which circular we are referring to?
42 page.
Page?
Page 44, my lord.
44. Clause 2, arrear in respect of retired to be retired employees. This is given on 17/8/2010 by the Assam Cooperative Bank. In respect of employees who retired during the period from 1/1/2004 to 30/4/2010, no arrear shall be paid. In respect of employees who retired during the period from 1/5/2010, this is after this, and after, areas shall be credited to the bank account in a single installment, and after adjustment of interim relief, other allowances, expenditures or maintenance, etc. Fixation in the revised scale and rate paid thereon has been done with reference to so and so. So you agree that for the exclusion of those people who come within the ambit of 1/1/2004 to 30/4/2010. Yes. Now,
My lord, what happened? Here, that in the circular itself, there is a board decision. The board of the director took the decision
on top, the board of Bahia in its meeting dated
27/7. That board decision was annexed with the additional affidavit filed by the respondent.
Okay. Where is it? Onidhar Chaudhary?
Yes, no, my lord, by the bank.
Okay. Okay, 1, 2 and 3.
Yes, my lord, 2 and 3.
Where is the affidavit?
File on, we got it on 23/7/15.
2015.
My lord,
No, affidavit filed on, there is one affidavit filed by respondent number 2 and 3. One Hemant Kumar Kakoti.
Kakoti, my lord, that is in an additional affidavit.
Oh, you are mentioning about some additional affidavit?
Additional affidavit filed by the bank.
Yes, got it.
At page 6, your lord, you will find that.
Yes,
Sorry.
page 6.
That is the discussion of revision of pay. May I read it? The House had a discussion on the memorandum placed by the managing director giving detail of proposed pay package for the employees of the bank. The managing director, however, apprised the House that even though the suggestion in the revised pay scale has been given as per the formula adopted by Government of Assam, there has been certain deviation in the matter of specific allowances like charges, allowances given to the employees of the bank, and requested the board to take a judicious view on this issue. He further clarified that some other allowances specific to the employees of the bank has been proposed to be abolished in the proposed revised pay scale. He also stated that with abolition of these allowances, the service condition of all employees under the particular grade would be at par with each other, and accordingly all employees in a particular grade would be required to perform all the duties required to be performed by employees under that grade, irrespective of their designation in that grade. After thorough perusal of the memorandum, the chairman opined that except the deviation suggested in case of running pay band, grade pay, fixation of pay in revised scale, and stagnation increment, the proposed suggestion should be in accordance with the formula adopted by the Government of Assam. Taking part in the discussion, the representative of employees of the board requested the House to incorporate the allowances specific to the employees or officer of the bank in the proposed revised pay package. Reacting to this, chairman, however, opined that this matter may be brought up for discussion in a separate meeting in the board for consideration and decision. The House unanimously agreed to the views expressed by the chairman and thereafter adopted the following resolution. Resolved that revised pay scale for the employees officer of the bank be declared as per the formula adopted by the Government of Assam with suitable modification as and where necessary as per details given here. The government formula was adopted. What is the in the clause 2 in the circular is a ditto of the government formula, and that formula was still before this honorable court by the government employees.
No. You see, at the third paragraph of that document, Annexure A,
yes, Lord.
it says, taking into account the partner, the second paragraph, after thorough perusal of the memorandum, the chairman opined that except the deviation suggested in the case of running pay, grade pay, fixation of pay in revised scale, which is the ROP, stagnant increment, the proposed suggestion should be in accordance with the formula adopted by the Government of Assam. Now we are concerned with the cut-off date.
Cut-off date, Milord, that is why I am coming to the cut-off date. The entire clause inserted in the circular from the government formula.
No, because if you see, this is as per the ROP.
Yes,
ROP of which one? ROP is
ROP of the state government, Milord.
ROP is which one? 2010?
2017, Milord.
2007.
Oh, Milord, sorry, Milord.
No, it is the sixth ROP. It's the sixth ROP that came into effect on 2010.
Pay commission in
giving
2008,
effect
Milord.
from 1/2006.
Six.
Isn't it?
Yes. 2006.
And that ROP is the sixth ROP. Now, ROP that is only for the government employees.
Government employees.
Now they have chosen after 2010 because the government approved it from 1st of March or 1st of April. What is that date of 2010? ROP 6 ROP 1/5. Anyways, so they have done it. Pursuant thereto, they have taken a decision that they are not going to give the benefit from 1/1/2006. The entitlement of a revised scale will be only from 1/1/2006.
They also, in the government also, excluded a portion of 1/1/2006 to 31/3/2009.
No. Government gave that.
No, government excluded, similarly, government also adopted that formula that during this period, those who retire, they are not entitled to revised pay.
Yes.
That was adopted by this corporation. Milord, I am relying on that judgment, Milord, which
Yes,
is
show me
declared.
that judgment. So you are relying on that order passed where there was a challenge to that.
Yes.
They're not giving the benefit of that period.
That period.
Just 1 minute. ROP. as per this notification of the Assam ROP 2010, yes, although it come into effect from 1st of January 2006, but the clause 2 or rule 2, which was the exclusionary clause, only limited that the government employees who have retired in the afternoon of 31st of December 2005 shall not be entitled to this benefit of these rules. Anyways, let us see what is mentioned here.
In this case, if your lordship take up the at paragraph 14, your lord directly,
Paragraph 14. Yes.
clause 42.a inserted by the government read as follows. Area in respect of retired oblique to be retired employees. In respect of employee who retired in the period from 1/1/2006 to 31/3/2009, no area shall be paid. If you not to compare with the
No area shall be paid in respect to the employees who retired in the period from 1/1/2009 to 31 area shall be credited. In the head of the solution. Employees who must be attributed to some recognition.
this clause was curtailed in the
So here the court applied DS Nakara and said that further subdivision of those people who are going to retire, that to retrospectively would not be proper.
the violative of accordingly court. So if you look to compare that provision of state government as well as the Defense Bank circular, what even word wise same, only period was expected. And therefore that condition they adopted from the government, that provision no longer in existence. You know, similar benefit we are all set.
So that is your case. It is your case is that it is covered by the in respect to the state, where the state have adopted a similar yardstick which has been set aside by this court, the division bench.
And the state provision was adopted by them because the resolution said whatever the formula adopted by the state government, we accept it. That formula,
Irrespective of that, but the question which is involved therein, in that case pertaining to the state, a similar question arises here also, And there can be no further bifurcation of the amongst the pensioners unless there has to be a good rational reason. And when the division bench thought it that there could not be bifurcation even in spite of anomaly committee report, then the same yardstick should be applied to your case. Mr. Goswami, I'll hear you after I come in 5 minutes. Huh? That is your case in fact. Last 12 years long litigation. No, I was telling him that the petition, the order sheet has become thicker than the petition.
True.
Yes, Mr. Goswami.
My lord, may kindly peruse the distribution of page 34. Page 34 of the report.
Of the affidavit of
Writ-
petition.
My lord, it says clause number 1, date of effect and payment of arrears, which is impugned, my lord. Here. The revised pay structure, which is pay structure, my lord, shall be effective from 1/5/2010, but the revised pay of the employee shall be notified notionally fixed as on 31/12/2005. Arrear amount with effect from 1/5/2010 shall be paid in a single installment to respective bank accounts of the employee. Interim relief, other allowances as calculated by so and so. Expenditure on car maintenance paid to the employee with effect from 1/5/2010 shall be recovered from the arrear amount so released. So here is a case, my lord. It is specific to revised pay. Now nothing to do with pension, my lord. We are giving the cutoff date. We have fixed the cutoff date from 31/5/2010. So it's
In fact, clause 1 is not put to challenge. They have challenged only clause 2. If I'm not
yes,
wrong.
yes, my lord. If now we come to clause 2, my lord. In respect of employees who retired during the period from 1/4/2004 to 30/4/2010, no arrear shall be paid. It speaks about, my lord, arrear salary, not the retirement benefit, my lord. In respect of employees who retired during the period from 1/5/2010 and after, arrears shall be credited to their bank account in single installment after adjustment of interim relief, other allowances, expenditures on car maintenance. So it is about arrear pay, nothing to do with pensionary benefits. My lord, the judgment that my learned senior colleague has, my lord, referred to of the honorable single judge, my lord. There, my lord,
Division bench. Oh, single judge.
single judge. That was, my lord, initially put to challenge in a writ appeal. Then, my lord, in writ appeal, a judgment was placed. I'm just giving that two orders, my lord. Yes. Yes.
Now they sought for review.
Initially, a writ appeal was preferred.
Then
In
that
the-
I've seen it. It is enclosed out here. You are referring to the order of 27/3/2018.
Exactly, my lord.
Justice Ajit Singh and
Justice Manjit Bhai. That's the order, my lord.
Yes, I have seen.
That
It's there.
third paragraph, my lord, the learned senior additional AG, Assam in the light of annexure C of appeal memo and decision of the Supreme Court in the state of Punjab and others versus Amarnath Goel and others reported in 2005, 6 SCC 754 with the liberty to file review petition placed for withdrawal of the present appeal. Accordingly, my lord, the judgment was kept in abeyance, my lord, till the review was decided. Now, my lord, review has been decided against the state, my lord, against which, my lord, another appeal is being preferred next week, my lord. So, this review has been decided on 14/3/2023. The review filed by the state has been dismissed. Here, my lord, in that review order, if my lord peruses, page number, my lord, paragraph number 11, my lord. Review was basically dismissed on this ground. It is seen that it is not the case of the petitioner that the case of the state of Punjab and others versus Amarnath Goel and others was placed by the learned counsel for the review petitioner while making his submission. Therefore, the court did not have the occasion to deal with the state case law. A mere discovery of a case citation, which purportedly helps the review petitioner, is not a good ground to entertain a review application. The learned counsel for the petitioner has not been able to cite any provision of law or decision by a superior court, including High Courts or Supreme Court of India, that a case citation which was not referred to while the writ petition was being heard is a good and sufficient ground for the High Court to exercise the power of review. It is the considered opinion of the court if a case has been decided without taking into consideration of the relevant case law, the error can only be corrected in appeal and not by exercising power of review. While my lord begging to differ, my lord, if a judgment that holds the field has not been placed and a subsequent judgment has been passed, the subsequent judgment gets per incuriam, my lord. That has not been taken note of in this review petition, my lord. The senior counsel for the petitioner has rightly pointed out that in the case of Amarnath Goel, the respondents who were the employees of the government of Pakistan, Punjab, and had retired during the period from so-and-so, were seeking the benefit of a circular dated so-and-so under the state government employees who had retired or died after so-and-so were entitled to get area death gratuity on the basis of addition of certain portion of dearness pay to the basic pay so-and-so. According, my lord, paragraph 4, therefore, prima facie, it is not a case where the error apparent on the face.
Further read that, which was refused to them.
Yes, my lord.
However, the subject of the case of Nakara was for claiming a pension.
Revision of contributory.
As per the office
the formula for computation was liberalized but made applicable to government servants who were in service on 31/5/1979 and retired on and from that specified date. Thus, it was submitted that the ratio in the case of D.S. Nakara was more applicable in the case of respondents than the case of Amarnath Goel. Supra, thus the court finds some force in the state submission, but no opinion is expressed on such submission. Therefore, prima facie, it is not a case where the error apparent on the face of the record is self-evident and can be discovered without a long-drawn process of reasoning, and definitely the matter cannot be decided without in-depth examination of the ratio laid down in the case of D.S. Nakara. The case of Brij Chowdhury was also the case relating to the claim of death cum retirement benefit, and therefore the state case was decided in the light of decision of the Supreme Court of India in the case of Amarnath Goel. There is a coordinate bench judgment also, my lord. That is that Biraj Chowdhury, my lord. We may now refer to the case of the Aribam Tulesar Sharma versus Aribam Pisak Sharma, where the Supreme Court of India has observed.
This is as regard the power of review, 63 or 79.
My lord.
79 follows 63.
My lord. Exactly. My lord, this was a review, my lord, under Article 215. It is not a review under CPC, my lord.
Okay, now the question therefore is, as there no orders have been passed here. So on one hand, there is an order passed by Justice Goswami,
right,
where he says that that is applicable and it has attained finality for that facts of those cases. And as to whether the judgment in Amarnath Goel, if applied, would have changed the order which was passed in by Justice Goswami.
Right.
So let us see Amarnath Goel then.
Yes, sir. Before that, may I take your lordship to D.S. Nakara? Because, my lord, the D.S. Nakara, that was in the context, it was 1983 judgment, my lord. It was in the context of classification of among the pensioners. It has nothing to do with back wages. My lord, here we have, this case is concerned not about pensionary benefit. It's about area salary, my lord. So that was in the context of pensionary benefit. 1983, 1 SCC 305.
In this judgment, the first paragraph is very nice.
Yes.
It gives you a, it dates back to the Tudors,
My lord.
where his reference is made to Wolsey, when he says that if Wolsey would have served God more than the king, he would have got more benefits.
And very difficult to pronounce some of the words also.
Yes, tell me. Yes, Nakara. But anyways, Nakara was for the purpose that Article 14 was brought into the picture because of the fact that you cannot have classification
among the pensioners. Here we are not doing anything like that, madam. We are not paying the area salary.
So let us see this judgment in Amarnath Goel.
My lord. It is.
I think you are referring to Nakara because of that.
Because of that, my lord.
So here your case is the question of there being a sub-classification of pensioner does not
Doesn't
arise
arise.
because there is no discrimination amongst pensioners.
Regarding retirement benefit, we have not done anything.
You are saying that those persons concerned who have retired from 1/4 this particular date, 2005 or 2006 to 31/5/2010, would not be entitled to the arrears salary. But there, for the purpose of computation of pension, it will be worked out.
Same. For
That is
pension,
what
they will
you are
get,
saying.
that is precisely my case.
Yes.
That we are not making any classification among the pensioners.
Okay. let
For
us see
example, my
that-
lord, this petitioner retired on 29/12/2007. So from 7 to 10, he has not worked also. My lord. This, my lord, Amarnath Goel is my
So
lord.
your thing is that period till 2007, is he going to get the arrears salary?
No. Nobody is going to. Even the working employees are also not getting money. There is no classification, man. The employees who are working even after 2010, they are also not getting anything from 2005, 6, 7, 8, my lord.
So they are not giving effect from that.
Exactly.
Which was given in the ROP.
Yes.
That they were going to get effect from 1/1/2006. That has not
That-
been given the benefit of that.
Exactly, my lord. They are also not getting anything. They are not getting any area benefit, my lord.
So if any order is being passed, thereby giving them, it would be, in fact, it would otherwise violate clause 1. Because clause 1 says that the debars those persons who
Exactly.
are working for the pay.
Exactly.
They are not getting it.
Exactly. Then, my lord, the retired persons, my lord, will be getting more benefit than the working employees. my lord. Then only, my lord, there will be classification.
Date and period. So that is clause 1. The revised pay structure shall be effective from 1/5/2010.
Yes.
But the revised pay for the employees shall be notionally fixed as on 31/12/2005.
Exactly.
Arrear amount with effect from 1/5/2010 shall be
be
paid
paid.
in single installments. So you are not paying for the period from 1/1/2006 to 1/34/2000.
Irrespective of serving and retired employees.
So you are not giving anything.
Anybody is
So
nobody
the
is getting.
question of them getting it does not arise.
Exactly. Even, my lord, if we get them, if clause 2 is set aside, my lord, they will be placed in a better position, my lord. The retired person, the working employees will not be getting anything. Retired employees will be getting.
So your basic case is that there is a huge difference between this thing and state
Yes, sir.
government,
It
because
is
state
pure-
government gives the benefit from 1/1/2006.
Exactly.
And therefore, those persons concerned would have been entitled,
Exactly.
which is not the case here,
Yeah.
because you are not given even to the persons who are existing.
Exactly. We have
And the
adopted.
ratio out there cannot be applied
Cannot
because
be
of the
And, my
various
lord,
judgments of the Supreme Court to the effect that one additional fact or a different fact would make a whole lot of difference.
and the judgment, my lord, of the Honorable Single Judge, my lord, has heavily relied on DS Nakara, my lord. And DS Nakara was in the context of discrimination among the pensioners, my lord.
Now, anyways, that judgment, should we go into that in view of that judgment of the Supreme Court in 1975 and even also of the judgment in 2022 9 SSC, the Kotak Mahindra,
My lord.
Kotak Mahindra Bank, where in paragraph 64, I think the Supreme Court has held that one additional fact or a different fact, if applied to the same those facts, make a whole world of a difference, and as such, the ratio cannot be applied. So, without touching on that, this court can very well dispose of, because the facts in that case and this case is different. Because if you see the ROP of 2010, as I could see, here it says of the state governments, here it says that these rules shall be called the Assam Service Revision of Pension Pay Rules 2010. They shall be deemed to have come into effect from 1/1/2006. Then here one thing is that unless specifically extended under express orders of the government, these rules shall not apply to, amongst many, government employees who have retired in the afternoon of 31st of December 2005. So there is no exclusion of those people who are there or who retired after 1/1/2006.
Yep. Why I'm relying on this, my lord, Amarnath, because Amarnath Goel, my lord, is a letter judgment wherein my lord DS Nakara was discussed and my lord.
Very well. Where is it? Is
Yes,
a very long judgment?
My lord.
Is it a very long judgment?
Not very long, my lord. I'll be relying on 2 or 3 paragraphs only. 2005 6 STC 754. Five volume 6.
6 SCC
754.
Oh, he has got it.
Paragraph 3 for the my lord issues. The respondents are employees of the government of Punjab who retired during so and so. They sought the benefit of a circular 13/12/96 under which the state government employees who retired on or died on or after 1/4/95 were entitled to get retirement benefit gratuity. That gratuity on the basis of addition of 13 portion of the dearness pay to the basic pay. This benefit was refused to them. The respondent challenged the decision of the state government. So that was the factual background, my lord. There are several cases were clubbed, my lord, and finally, paragraph 22, my lord. Paragraph 22. The thrust of the arguments by the learned counsel on behalf of
Let us read paragraph 20 also.
My lord. A large number of employees, both of the central government as well as state government of Punjab and Himachal Pradesh, who had retired prior to 1/4/95, applied for getting the additional benefit of increased quantum of death cum retirement gratuity up to the increased limit of rupees 2.5 lakh. Their claims were rejected in some cases. In other cases, CAT and High Court took the view that such employees who had retired between 1793 and 31/3/95 were also eligible for the aforesaid benefit. Thus, the employees whose cases were wholly rejected or partly rejected and partly granted, as well as the Union of India and the state government, are in appeal before us. The thrust of the arguments by the learned counsel on behalf of the employee has been on the alleged violation of Article 14 of the Constitution. They contend that the decision of the central government, state government to make available the increased quantum of gratuity with revised ceiling only to employees who retired or died on or after 1/4/95 is discriminatory and arbitrary. They also contend that all the retirees dead persons form a homogeneous class, and any discrimination or distinction between retirees, dead persons prior to 1/4/95 and those who retired, died on after 1/4/95 has no rational basis, nor was intended to serve any purpose. Heavy reliance was placed on the judgment of this court in DS Nakara versus Union of India. We are afraid that the refrain of DS Nakara has been played too often to restrain initial charm, which has been worn thin by subsequent dicta. The learned counsel for the Union of India and the state government contended that we can skip, my lord.
Paragraph 25.
Yes, my lord. The only question which is relevant and needs consideration is whether the decision of the central and state government to restrict the revision of quantum of gratuity as well as the increased ceiling of gratuity consequent upon merger of a portion of dearness allowance into dearness pay reckonable for the purpose of calculating gratuity or was irrational or arbitrary. It is difficult to accede to the argument on behalf of the employees that the decision of the central government, state government to limit the benefit only to employees who retired or died on or after 1/4/95, after calculating the financial implication thereon, was either irrational and arbitrary. Financial and economic implications are very relevant and germane for any policy decision touching the administration of the government at the center or at the state level. My lord, if we skip next paragraph, my lord. Paragraph 28, my lord. 10th line from bottom, my lord. The line starting with the right hand side, starting with the word the central government took. The central government took a conscious stand that the consequential financial burden would be unbearable. It therefore chose to taper down the financial burden by making the benefits available only from 1/4/95. It is tried that the financial recommendations of the pay commission were not ipso facto binding on the government, as the government had to accept and implement the recommendations of the pay commission consistent with its financial position. It is precisely what the government did. Such an action on the part of the government can neither be characterized as irrational nor as arbitrary so as to infringe Article 14 of the Constitution. DS Nakara, which is in the mainstay of the case of the employees, arose under special circumstances, quite different from the present case. It was a case of revision of pensionary benefit and classification of pensioners into two groups by drawing a cutoff line and granting the revised pensionary benefit to employees retiring on or after the cutoff date. The criterion made applicable was being in service and retired subsequent to specified date. This court held that for being eligible for liberalized pension scheme, application of certain criterion is violative of Article 14 of the Constitution, as was both arbitrary and discriminatory in nature. The reason given by the court was that the employee who retired prior to a specified date and those who retired thereafter formed one class of petitioners. The attempt to classify them into separate classes group for the purpose of pensionary benefit was not founded on any intelligible differential, which had a rational nexus with the object sought to be achieved. However, it must be noted that even in cases of pension, subsequent judgment of this court have considerably watered down the rigid of the view taken as in DS Nakara, as well as we shall see later in TN Electricity Board and V. Viraswamy. In any event, it is not a case of continuing benefit like pension. It is one-time benefit like gratuity. Here also it was a one-time benefit of back wages, salary. In Union of India versus PN Menon, while implementing the recommendations of the Third Pay Commission with regard to the dearness allowance, dearness pay linkage linked to average index level 272, which was to be counted as emoluments for pension and gratuity under the Central Civil Service Pension Rules 1922. The central government had fixed the criteria cut-off date and directed that only officers retiring on or after the specified date were entitled to the benefits of the dearness pay being counted for the purpose of retirement benefit. This was challenged as arbitrary and violative of Article 14 of the Constitution. This court turned down the challenge and observed, not only in matters of revising the pensionary benefit, but even in respect of revision of pay scales, a cut-off date on some rational or reasonable basis has to be fixed for extending the benefit. This can be illustrated. The government decides to revise the pay scale of its employees and fixes 1st January of the next year for implementing the same, or the first day of January of the last year. In either case, a big section of its employees are bound to miss the said revision of scale of pay, having superannuated before that date. An employee who has retired on 31st December of the year in question will miss that pay scale only by a day, which may affect his pensionary benefits throughout his life. No scheme can be held to be foolproof, so as to cover and keep in view all persons who were at one time in active service. As such, the concern of the court should only be while examining any such grievances to see as to whether a particular date for extending a particular benefit or scheme has been fixed on objective and rational consideration. In Action Committee Southeastern Railway Petitioners versus Union of India, it was held that a merger of a part of dearness allowance as dearness pay on average price index at level at 272 with reference to different pay ranges, fixing a cutoff date in such a manner was not arbitrary, and the principles enunciated in DS Nakar was
Mr.
not.
Goswami, leaving aside all these things, don't you think that this particular paragraph in
22,
paragraph 28,
madam.
which gives the state a discretion to fix a cutoff date, which have also been approved in the Constitution bench judgment in T. Sampath, that they have an absolute discretion to have a cutoff date. And in the instant case, the cutoff date was fixed on a particular date. Now, if clause 1, if the benefit under clause 2 is being given,
the people under
it
clause
will
1
affect
gets
the clause 1.
Exactly.
Understandably, if a person concerned, if the clause 1 gave the benefit from 1/1/2006,
then it would have
been a case
discrimination
of
to
here
clause
that
2.
he would have been entitled to 2006 till 2006.
Exactly. It would be discriminatory.
And
to them.
thereupon, his computation has to be made on the basis of the 2007. There's no that would, these are cases which you are referring to is a case pertaining to a subclassification in the pension.
Exactly.
which
Regarding
have been
pensionary
watered
benefit.
down after Nakara.
Yes.
Because Nakara, the main submission was that that why you are having the liberalized pension scheme is for the purpose that I am, the basic idea is that we are trying to get more people into the government jobs. And as such, we are making the liberalized pension scheme more attractive. The Supreme Court says that this person is going to join now and work for 30 years. You may have some other pension scheme then. But what is going to happen to those people who are still working and you have not giving them? And as such, it says that you cannot have a sub-classification to that. That is in Nakara.
So that's why.
But here, whether Nakara or even this Amarnath Goel, does it apply because of the fact that clause 1 and clause 2 categorically mentions one aspect of the matter where there is no classification.
And nobody is getting that amount, not even the working employee.
Then where is the question of classification?
Exactly.
And the difference with Justice Goswami's order or even Justice Surana's order, that judgment, how is it going to be made applicable? Because it was made specifically clear in the ROP of 2010 that it will come from 1/1/2006, irrespective of anybody.
My lord, I was referring to the Nakara because, my lord, the judgment of my lord Justice K.K. Goswami has been relied upon, which was based on Nakara. And this Amarnath, my lord, because there is a, my lord, liberty granted to the government that you can take your own call regarding financial implication. And precisely it is our stand in our affidavit that
28.
In our affidavit, my lord, we have specifically stated, my lord, this financial burden we cannot withstand, my lord.
No, and there is no classification.
There is no classification.
Even with working also.
Exactly. We have, my lord, worked out in my affidavit that bank was running in loss. We cannot take that burden, which was estimated to be 8 crore additional, madam. And
No, that would not be an 8 crore additional. That has to be also with respect to those persons who are working also.
Exactly, ma'am. They will also get, my lord. Not only these.
Because the moment you give it to them,
Everybody will get. Exactly. And secondly, my lord knows, my lord, in Uma Devi's judgment, my lord, in paragraph 19, it has been specifically held, my lord, financial burden by the orders of the court, my lord, has been, my lord, deprecated.
No. If there is a financial burden which is required to be made, just for example, you take his services.
And we don't
ask
give
him
it.
to work, you don't pay.
We
And
don't
then
pay
you
him
say
pay.
that,
Yes.
yeah, I don't have money.
Yes, ma'am.
Then are you going to say that Uma Devi will come to your help?
No, definitely not, my lord. Legal entitlement they will get, my lord.
So that is why in Uma Devi, the basic reason why it was said is directing a regularization amounts to bringing somebody within the fold of government service.
Exactly.
And as such, if you are doing so, who is going to bear the burden?
Exactly. One
Unless
line.
the government doesn't want.
Yes, ma'am. One sentence from that judgment, my lord, paragraph 19. The burden may become so heavy by such a direction that the undertaking itself may collapse under its own weight. It was precisely our case, ma'am. We could not have withstand that load, ma'am.
That is a different thing, but how are those things?
Otherwise, no, ma'am. There is no classification.
I think you should stick to 1 and 2.
Right.
Better answer.
Right.
And I think the most appropriate judgment would have been T Sampath, where you have a power to have a cut-off date. The government may say that is why ROP rules of 2010. You have a copy of the ROP rules of 2010?
No, ma'am. Sorry.
This bank is a public sector undertaking, public undertaking.
So it's a cooperative bank, ma'am. Around 15 to 20% share is of state of Assam. It's regulated under section 55 of banking regulation.
Even forget about this, even the corporations, which are government corporation, AFDC,
My lord.
they would not be entitled to the ROP automatically because they are not government servants.
It has to be adopted by their board, ma'am.
Here it says, save as otherwise provided by or under these rules shall apply to all employees appointed to services or posts in connection with the affairs of the state of
Exactly.
Assam and which are under the rule-making control of the governor of Assam,
Exactly.
unless specifically extended under express orders of the government, these rules shall not apply to the members of All India Services, members of Assam Judicial Services. Therefore, for these Assam Judicial Services, it has to be a thing has to be done under the precises or the aegis of the High Court. Like the High Court judge's salary, the central government may say many things. They may have the Central Pay Commission and all, but then it has to be placed by the under the Supreme Court. It has to be done under the aegis of the. This is how it is to be done because you can't apply this, and here also you can't.
Even I have done a case of our employees association, my lord, under Article 229. High Court has suggested a pay scale for our employees, my lord. But 229 mandates, my lord, concurrence from the governor. That the state is refusing.
No, that is required because the payment comes from the
State.
Government.
And I have seen, my lord, the Constituent Assembly debate on Article 229. It says there may be heartburning between the employees of the Secretariat and the employees of the High Court.
It can happen. No, forget about that. A judicial officer, a judicial officer, Munsif, or even a civil judge out there, he may not get us just for example the 7th pay commission. He may not get it unless it is extended specifically by the government because the payment has to come from there, from the government revenues.
Here also, my lord, we have, instead of going for that extensive calculations, my lord, we have adopted it. But depending upon our financial soundness, my lord, we have fixed the cutoff date.
I think you have done it. Yes, Mr. Sir.
Evidently, my lord, they adopted it. The formula framed by the government.
No, they have adopted it, but the thing is, clause 1 only gives the benefit from a particular date. Then if a person who is working is not going to get that benefit, how can you get a benefit because of the fact that you are retired? There's no doubt. For the purpose of computation of your pension, it has to be worked out on the basis of the 6th pay commission. There's no quarrel with that. They are doing it. You are doing it.
Yes.
But it is only for the purpose of that period. There won't be any area salary prior that date. It will be only counted from the date when the notification has come into being. That is more particularly 1/5/2010. Although the notification came later on, but it was given retrospective effect from 1.
Yes, notification of August, my lord, of 2010. We have given it from May.
It was given from 1/17/8/2010, but it was given effect from 1/5. So your computation of pension has to be fixed during this period only from this particular period. 31/12 shall be notionally fixed as on 31/12/2005, but there shall not be any areas. So your fixing will be on the basis of that, as on that day, because every year there will be every 6 months there will be a DA. Every 6 months thereafter again there is a DA and all this.
They will be getting their pension on the basis of increment from 2005, my lord.
Notionally 31/12/2005.
Exactly. Their pension will be fixed notionally. Actually, in Apex Bank, there is no pension. It is PPF, gratuity, and leave encashment.
But you are sure, no? The pension will be computed in terms with 31/12/2005.
Apex Bank, my lord, there is no monthly pension. It is we pay gratuity, PPF, and my lord, leave encashment. So gratuity amount, whoever gets what is the amount they will get.
So the gratuity will be fixed in terms with by calculating the amount on the basis of 31/12/2005.
Exactly.
That is your specific stand in your affidavit.
That I have not dealt with, my lord.
You have filed an additional affidavit also.
Yes, my lord. additional affidavit to my lord indicate our financial soundness of that time. Good.
No, as regards this, because here you are mentioning, you see, but kindly come to page 34 of his petition.
My lord.
The revised pay structure shall be effective from 1/5/2010.
My lord.
Okay. So from 1/5/2010, you are going to give them revised pay structure.
Yes, my lord.
But the revised pay for the employees shall be notionally fixed as on 31/12/2005. So it will be fixed from that,
That from that period.
but there shall not be any arrears paid.
They will not get it.
Area amount with effect from 1/5/2010, because this has happened only on 17/8.
Exactly.
So there will be an area
Amount 3-5 months area.
3 months shall be paid in one single installment through respective bank account of so and so.
Exactly.
So here the fixation of the gratuity, we are giving what?
But we are following the Gratuity Act.
The gratuity, then
Gratuity, Provident Fund, and leave encashment.
provident fund and leave encashment.
These are the three
Now, leave
superannuation.
encashment, would it be dependent upon the salary?
Yes, ma'am.
Gratuity, it would be.
On the gratuity, my lord, we follow the Gratuity Act. As per Gratuity Act, there are revision of amount time to time, my lord.
No, would it be dependent upon the pay?
No, it is not dependent upon payment.
Gratuity, no.
No, ma'am.
So leave encashment, it will.
Yes.
And provident fund?
Provident Fund, my lord, it's a organization wherein we deposit and they also deposit some.
So they deposit on the basis of a particular salary.
Yes, my lord.
So it will be dependent on the salary.
Salary. But my lord, the working employees are also not getting for that period. From 5 to 10 onwards, my lord, up to 10, my lord, working are also not getting that much.
Here he is only asking for the revised pay,
Exactly.
not for the arrears.
They are asking nothing, my lord. They say they should get that to 1/5/2010 to 31/12/2005 to 1/5/2010. That salary, enhanced salary they want.
That too, they won't. But would that have an impact on the gratuity and all these things, the revision on the provident fund?
Well, gratuity is as per the Indian
No,
Gratuity Act.
leave encashment.
Leave encashment is fixed on, my lord, the days of service. So definitely it will have some impact. But for that period, my lord, working employees are also not getting money. For example, my lord, if we calculate leave encashment for say around 200 days in his service career, so the date on which he retired, my lord, salary of that
Now,
date.
if a person normally leave encashment is on the basis of 200 or 300 days.
Yes, ma'am.
Which means in normality in the state government it is 300 days, which
Yes.
means 10 months of salary.
Yes.
10 months of last
Salary.
salary.
Last salary.
Now, in view of one, there will be a change from 31/5.
Exactly.
For them also, they will be entitled to the person who has retired in 2007. Then the leave as encashment has to be calculated on the basis of that. Don't you think so? If
we are giving it to the current employee,
otherwise it will have a violation.
there will be classification.
Because here what you are saying, you have made very clear that, but the revised pay for the employees shall be notionally fixed as on 31/12/2005. So their pay will be
months. I
fixed
got it.
from 31/12. Those persons who have retired in 2007 or 8, they are not entitled to the area salary. No, nothing to that.
Since, my lord,
which is being given.
current employees are getting it notionally fixed from 2005.
They are also
For the purpose of gratuity, sorry, not
Leave
PPF and leave encashment, it may have some effect.
PF is a different thing because it is an equal contribution which is being made by the petitioner and the PF.
For leave encashment.
So that would not be possible now. Because this has happened in 2011. How do you make it now? Because the petitioner did not pay his dues also.
Exactly.
So that would be very difficult. But for the leave encashment, that
encashment.
has to be done. Otherwise, it will violate clause 1.
May I submit one thing, my lord?
Yes.
Instead of taking time to take instruction and place it before your lordship, my lord may pass an order to the bank to consider that aspect, and I will impress upon them.
No, I'll pass the order. Make it clear. In your presence only.
Yes,
I'm
my lord.
passing the order now.
Yes.
Disposing it of 2011 matter.
That is what I'm saying, my lord.
One solace you get is disposing it of. Because that thing, if you give
Yes,
it, and also
I
petitioner
understand.
gets something, and the fighting of a litigation by Mr. Kotoki for the last
No,
year.
no, my lord. It's a 10-pound beef, my lord. That's a retired person.
Understood. Heard Mr. S. Kotoki, the learned counsel, appearing on behalf of the petitioner. Mr. Ian Goswami. The learned.
Standing counsel effect.
The standing counsel for the of the respondent number 2, that is the Assam Cooperative, the standing counsel of Assam Cooperative Apex Bank Limited represents on behalf of respondent number 2, 3, and 4. And where is the state government employee? The lawyer? State government employee.
State government has no role to play. I can prepare for one.
You can't. They need, yes, Mr. S.S. Roy appears for the respondent number 1. The petitioner before this court has filed the instant writ petition challenging clause 2 of the circular, staff circular number 49/2010, dated 17/8/2010, on the ground that the said clause violates the mandate of Article 14 of the Constitution of India, inasmuch as there is no reasonable classification for not granting the petitioner the pay for the period from 1/4/2000, the enhanced pay for the period from 1/4/2004 to
1/1/2004 to
1/1/2004 to
34/2010.
34
2010.
2010. No. When did you retire?
Petitioner my lord retired on 39/12/2007.
31/12.
29/12.
29/12/2007. No, your area pay will be only for till 10 only. You can't get it till 2010.
Post-retirement.
That will be pension or whatever may be. But your entitlement may only till the date of your retirement, because you are asking for area, na? Area pay.
Yes.
By way of area, and after hearing benefit of the revised pay. So it will be only till your
Till
date of
superannuation.
retirement. Dated so and so.
29/12/2007.
The case of the petitioner herein that he joined the respondent number 1 bank on 1st of August 1970, and thereupon was transferred to several branches of the bank. And finally, the petitioner joined the Silpuguri branch on 26/9/1998 as branch manager. On 29/12/2007, the petitioner retired from service on attaining superannuation.
That may be 31/12.
29/12.
No, he attained the age of 60 on 29/12 and retired from that your lordship page 19 of the petition. Superannuation notice.
This is what you have written in your petition. How can
I
I
know.
help you?
Problem is
And had retired from service with effect from 31/12/2007. It is the further case of the petitioner that pursuant to the Assam Service Revision of Pay Rules 2010, which was brought into force from 1/1/2006, the respondent number 1 bank had also in its board meeting dated 27/7/2010 resolved that revised pay scale for employees / officers of the bank be declared as per the formula adopted by the government of Assam with suitable modifications as and where necessary as per the details given in the said resolutions. On the basis of the said meeting of the Board of Directors on 27/7/2010, the staff circular number 49/2010, hereinafter for short, dated 17/8/2010, hereinafter for short referred to as the impugned circular, was issued. The petitioner herein, having retired on 31/12/2007, is aggrieved by clause 2 of the said impugned circular. The same being relevant is reproduced herein under page 35. A perusal of the said circular reveals, said clause reveals that the said clause is in respect to those employees who retired during the period from 1/1/2004 to 30/4/2010. It has been mandated in terms with the said clause that in respect to such employees, no arrears shall be paid. However, in respect of employees who retired during the period from 1/5/2010 and after, arrears shall be credited to their bank account in a single installment after adjustment of the interim relief, other allowances, expenditures on car maintenance, etc. The reason why the benefit has been given to those employees who retired after 1/5/2010 can be seen from a perusal of clause 1 of the said impugned circular, which is reproduced hereunder. A perusal of the said clause 1 would show that the revised pay structure, page 34 probably, shall be effective from 1/5/2010. However, the salary of such person would be notionally revised as on 31/12/2005. It is further seen that the area amount in question is only taken into consideration for the period from 1/5/2010. Though the salary is notionally revised from 31/12/2005. Therefore, the area salary, as has been meant out, as has been stated in clause 1 of the impugned circular, has to be taken to be for the period from 1/5/2010 to 17/8/2010, or till such time the revised fixation takes place with effect from 1/5/2010. This board further finds it relevant to take note of another clause, which is clause 3 of the impugned circular, which is reproduced hereunder. A perusal of clause 3 will show that the fixation in the revised pay scale and the grade pay thereon has to be done with reference to the pre-revised pay scale in which the employee was actually drawing pay as on 31/12/2005. Therefore, a conjoint reading of clause 1, 2, and 3 would therefore show that neither the existing nor any person who retired with effect from 1/1/2004 to 30/4/2010 would be entitled to any arrears on account of salary till 30/4/2010. Although their salary would be notionally fixed with effect from 31/12/2005. At this stage, this court finds it relevant to take note of the submission made by Mr. S. Kotoki, the learned counsel appearing on behalf of the petitioner, that a perusal of the minutes of the meeting of the board of the respondent number 1 bank, more particularly the board meeting dated 27/7/2010, would show that they have adopted the pay scale for its employees as was given by the government of Assam in its ROP of 2010. The learned counsel have also referred to a judgment of this court, a judgment of the coordinate bench of this court in the case of the All Assam Retired Officers, Teachers and Employees Committee and others versus the State of Assam and others, reported in 2016 4 GLT 85. It is the specific case of the petitioner that the same judgment in the case of All Assam Retired Officers, Teachers and Employees Committee, SUPRA, was rendered in the case of the Assam Service Revision of Pay Rules 2010. And as in the board's meeting dated 27/7/2010, the said ROP, the said rules of 2010 was adopted by the respondent number 2 bank. The said judgment would be squarely applicable to the instant case. At this stage, this court also finds it relevant to take note of the submission of Mr. P.N. Goswami, the learned counsel, standing counsel, appearing on behalf of the respondent numbers 2, 3, and 4, who submits that pursuant to the said judgment in the case of Assam, All Assam Retired Officers, Teachers and Employees Committee, SUPRA, an appeal was prepared by the State of Assam, which was registered and numbered as Writ Appeal number 148/2017. The learned counsel, standing counsel, further submitted that in view of the judgment of the court in the case of the Supreme Court in the case of further submitted that when the judgment of the Supreme Court in the case of State of Punjab and others versus Amarnath Goel and others, reported in 2005-6 SCC 754, was placed before the division bench. The division bench of this court, by its order dated 27/8/2018, asked the petitioners, the state, was placed before the division bench. And upon inquiring that the said judgment was not placed before the single judge, before the coordinate bench of this court, liberty was given to the state to file a review application by bringing into the notice of the coordinate bench the judgment in the case of Amarnath Goel SUPRA. The learned standing counsel further submitted that the review application being filed was, however, dismissed by an order dated 14/3/2023 by a coordinate bench of this court. And the state at present is contemplating filing an appeal. Next. Be that as it may, the question, however, be that as it may, this court upon perusal of the judgment in the case of Assam, all Assam retired officers, teachers, and employees, Supra. The Assam, the Assam Service bracket revision of pay close rules 2010, as well as the impugned circular, sees the fundamental distinction between the rules of 2010 with the impugned circular. The rules of 2010 have been given retrospective operation from 1/1/2006, as could be seen from Rule 1B of the Assam Service Revision of Pay Rules 2010. However, in the instant case, as it could be seen from the impugned circular, that there is no distinction to that effect, and the said rules have been made applicable from 1/5/2010. It further appears that from clause 42A, that further appears that clause 42A did not give the benefit of area to those employees who retired during the period from 1/1/2006 to 31/3/2009. Whereas the same benefit was given to the existing employees. However, the facts of the instant case, as already stated, that both those that the employees who retired from 1/4/2004 to 31 that date 31/4/2010 34/2010, as well as those existing employees who worked during this period have not been granted the benefits of any area salary from prior to 1/5/2010, which is the fundamental distinction This court at this stage finds it relevant to refer to the judgment of the Supreme Court in the case of Pawan Kumar Dubey versus Union of India, reported in 1975, 90 years. More particularly, paragraph number 7, which is quoted here in below. A perusal of the said judgment clearly makes it clear of the said judgment would make it clear that an additional fact or a different fact may make a world of a difference while applying the same to similar facts. And as such, the same cannot be regarded as a binding precedent cannot be regarded as a ratio for the purpose of applying the same. When there is any further additional facts which are relevant to the issue. Therefore, taking into account the fundamental distinction between the case in the Assam Retired Officers, Teachers and Employees Committee, SUPRA, and the present case, this court is of the opinion that the said ratio cannot be applied to the facts of the instant case. Remaining, I will give it at 2.
At 2, may I be excused for some? My item is going on in court number 4 for some time now. So that will be done by KP Pataka. Post of Pataka.
Oh, he's there for the other side.
Okay. Also, there's one item, item number 19, 18. Actually, you are also fixed at 2, my lord. The last occasion, my lord.
Why should I take it up at 2?
You also said I will take it up at 2.
Did I say that?
Yeah.
Huh?
Yeah.
Okay. Then,
but by the government,
but did I say that I'll take it up at 2?
the last occasion.
Why will I say that? I don't think it is recorded out
Most
there.
probably not recorded.
I normally record it in the order when I say at 2. Because if I don't do it, otherwise, therefore, if you see item number 3 onwards, it's written out there to be taken up at 2.
Somehow misplacement, maybe. But we hard did that it will take it up.
Then, no, not today. No, that's already gone. We'll have it on after 3 weeks.
They fix my lord, your lord.
Together. Now coming to the facts of the instant case. And upon a perusal of clause 1 and 2 of the impugned circular dated 17/8/2010, it would be seen that the respondent number 2 bank have not created any unreasonable classifications insofar as the granting of benefits for revision of the pay scale between the retired employees during the period from 1/1/2004 to 30/4/2010, and those existing employees after 1/5/2010. This court further, taking note of the judgment in the case of State of Punjab versus Amarnath Goyal, Supra, and more particularly paragraph number 28, wherein it has been held that the state has the power to take a conscious stand depending upon the consequential financial burden to apply the benefits of the revised pay scale the scope of judicial review in respect to the challenge to the same circular on the touchstone of the declared law is very limited unless and until a case of violation of Article 14 has been made out. Nothing could be shown or could be discerned from a perusal of the materials on record which would show that the clause 2 of the impugned circular violates the mandate of Article 14 of the Constitution. Consequently, this court therefore holds that clause 2 is not in violation to Article 14 of the Constitution. And accordingly, no interference is called for. Next. Before parting with the record, this court put a specific query upon the learned counsel, standing counsel for the respondent number 2 bank, as to what are the retirement benefits which a employee gets from the respondent number 2 bank. The learned standing counsel, with all fairness, submitted that a retired employee of the bank, respondent number 2 bank, would be entitled to provident fund, gratuity, as well as leave encashment. He further submitted that leave encashment is given on the basis of the last drawn wages. Accordingly, this court is of the opinion that if clause 2 is opinion that upon a reading of clause 1 and 2, as the petitioner had retired on 31/12/2017, his last drawn wages has to be calculated. In terms with clause 1, thereby fixing it notionally with effect from 31/12/2005. Accordingly, this court, therefore, without interfering with clause 2 of the impugned circular, disposes of the petition with a direction to the respondent number 2 bank to grant the benefit of if not already granted, the leave encashment by notionally fixing the last drawn wages of the petitioner in terms with clause 1 of the impugned circular, thereby, that is, as on 31/12/2005. With the above observations and directions, the petition stands disposed.
The only thing that your lord, 2000, not 2017, 2007.
7, I'm sorry. 7 to you. Yes, Mr. NJ Khatuni.
And number 3 to 13.
Yes, what affidavit did you file?
Yes, my lord.
You have paid everything.
No, my lord. I have paid the sellable part, my lord, and I have bring on record, my lord, this one, my lord, report of the joint committee, my lord, where there are two components, my lord. One is sellable, the other one is unsellable.
Where is the affidavit?
My lord, my lord, kindly take up item number 5, my lord, first. Item number 5.
Yes.
Yes, my lord. The annexer A of the affidavit filed by today, my lord, page 54.
Annexer page 54. Ajani. Affidavit go aise. Joking.
Yes. My lord, petition number 6141.
6141.
Hillview.
6141. Got it. एक इवन बाकी जगह भरा दियो. Tell me.
This is the report prepared by the joint team after verification. Stock as on 31/8/2016, my lord. My lord, kindly see the first column, my lord. This is for sellable stock. The
Just
first one.
1 minute. Yes.
This is for
This is Annexure A.
Annexure A.
Okay,
This,
then
my lord, the first column, my lord, in
physical stock. As
physical
on
stock, then
2001/9/2016.
first column is for sellable stock, my lord.
Sellable.
Sellable stock, my lord. The amount of ad valorem levy involved on the sellable stock, my lord. Last row, my lord, total 2,25,23,849. And next row, my lord, it's a
Hey,
VAT.
that day there was a particular list which he has given, and
Yes,
some
sir.
item it will be there.
Yes, my lord. So in this, since, my lord, there is no requirement to pay the unsellable portion, that is why joint team prepared the inventory.
1,47,95,948 is unsellable.
Sellable. It is sellable.
No. Down below, if you see down below, total unsellable
Yes, yes.
is 13,15,164.
No, my lord, it is sellable, my lord. Yes, my lord, total unsellable is 13 lakhs. 13
And
lakhs,
the
15,000.
total transit total ad valorem excise levy is
54,300.
Total saleable VAT is 1,47 lakhs. 95,000.
Then unsellable-
Unsellable VAT is 7,64,000. Total transit stock is 3,51,000. Then
So, my lord, what I want to submit, my lord, because they have prepared the inventory showing the sellable and unsellable in view of the clause 6 of the order dated 29/8/2016, my lord. Because there is no requirement to pay the ad valorem levy and VAT on unsellable stock, because it has to be dealt with as per the established procedure. On the
As
report,
per?
as per the established procedure from the report of the Commissioner of Excise, clause 9 and clause 6. So that is why they have prepared this joint team report showing sellable stock and unsellable stock. And my specific case is that, my lord, I have
Mr.
paid.
Counsel, whatever may be,
Yes, my lord.
one thing is very clear.
Yes.
It is dependent upon the excise commissioner's order.
Yes. Yes.
Excise commissioner's order makes it clear that you are to pay this amount. Now there came an issue as regards an unsellable goods. Now that excise commissioner's order has not been put to challenge anywhere.
Yes.
So that is attained finality. Now you want the set off as regard this.
Yes, ma'am.
On the ground that this amount should not be paid.
Yes.
But that aspect went to the high, before the government.
Yes, that
And when the matter
I
went
have,
to the government, the government said that nothing doing. We have COVID. You have to pay this.
I have annexed that document, my lord. In
I have
this,
seen it.
in this, my lord, can you see
I
one
have
thing, my
seen
lord?
it.
No, my lord, they have not take any decision on ad valorem levy, my lord.
No, kindly see Annexure B,
My lord,
page 57.
yes, my lord. Annexure C, page 57.
Ah.
The Finance Taxation Department, that's the last paragraph, my lord. The Finance Taxation Department is of the view that since VAT involved on the non-consumable stock amounts to 18,21,71,547 is quite a substantial amount, and keeping in mind the current financial situation of the state government that arose due to COVID-19 pandemic, it is not feasible to grant exemption of the aforementioned amount, as it will put a considerable strain on the state financially. So, my lord, they
whatever
have
may
dealt
be,
with only
that
VAT, my
means
lord.
1 rupee of ad valorem is still the VAT is payable.
Yes.
Then clause 9 comes into picture. Until you don't don't set it aside. In view of clause 9, you are liable.
VAT is a tax payable on, my lord, sale, my lord. We are not
Whatever
selling
may
it. VAT is a tax payable on sale, my lord. But we are not selling because it is unsellable product. We cannot sell it, my lord. How can they demand for VAT, my lord? On the
Therefore-
unsellable stock, my lord.
Therefore, that order has to be set aside. If you don't set aside that
My lord,
order,
in view of their conduct,
let
my
us
lord,
assume that VAT is not payable on these goods. Understood, fair submission, that VAT is not payable. But this court is not deciding that as to whether the VAT is payable or not.
but my lord,
We are on the implication of clause 9. Clause 9 is very clear to the effect that you are to pay this amount. Unless you don't pay, you have to pay the establishment charge. Why were you sleeping all this while?
but my lord, this clause 9 has a correlation with clause 6, my lord. But they are not doing anything on clause 6, my lord. They have to.
If they don't
They have
do
to-
it, then what to do?
That is my specific prayer and the repetition, my lord.
I've seen the prayer number B,
Yes, my lord.
wherein it says that for a direction for
The best start.
demolition. Very well. Now the direction for demolition will be dependent on certain verifications.
Yes, my lord, that has been done, my lord. That has been done, my lord. In fact, yeah, in my petition, I have annexed that document that they are saying, my lord, they have admitted it, my lord. Kindly, my lord, kindly come to page 25, my lord.
First, let us see what is your affidavit in 4575 of 2021. Item number 3. Huh? Oh, you have not filed that affidavit?
Yes, I have filed, my lord. I have filed.
Why that has not come?
I have filed, my lord.
Okay, you give your copy.
Yes,
Yes, Mr. Pathak. Share it with this court.
Yes, my
Your
lord.
copy. That will be enough. How you have taken note of that one?
My copy, their affidavit, yes.
Let us see what we have done. Now the best part is here. Why haven't you enclosed the
Because
page 40? There is no corresponding annexure A.
Yes, my
here.
lord.
Why?
That is not there with my client, my lord.
Obviously,
That is why, my lord.
because the
But
amount
I have
is very high.
Yes, my
Here
lord.
you are showing
I'm not denying
6141 or 4161 because of a reason.
because I
The
can.
amount between the amount you paid
Yes, my lord.
and the amount which was to be paid is very less. You see, the amount as per the excise commissioner's order is 2 crores 41,43,444 and 1 crore 59 lakhs 111,922. That is the VAT. Now, out of these 2 crores 41 lakhs, you have already paid 2 crores 31 lakhs.
Yes, my lord.
The amount becomes very meager. Then 1 crore 59 lakhs, you have already paid 1 crore 53 lakhs. So the amount becomes very meager. But what about the question as regards item number 3?
Yes, my kindly peruse my affidavit at page 3, my lord. Page 3 of the affidavit. I have stated
What?
Stated the reason, my lord. What happened to this joint committee report, my lord?
Page?
Page 3, my lord. Internal
Yes.
page 3. As per the said report, the total ad valorem levy is 10 crore 26 lakhs 51,481 and VAT is 6 crore 28 lakhs 89,206. However, the department subsequently re-verified the stock of the petitioner by constituting a subcommittee. The said subcommittee revised the demand made by the joint team. Since the demand made by the subcommittee is not based on actual physical stock present in the warehouse of the petitioner, therefore the petitioner demanded for further re-verification of the stock, which has been allowed by the department. In fact, the re-verification process is currently going on in the warehouse of the petitioner.
Now also?
Yes, my lord.
After so many years?
Yes, my lord.
I do not have instructions.
This is
So Lordship, if the re-verification process is going on, that means as far as this petitioner is concerned, there is definitely a requirement of having excise personnel.
that I'm not
present at-
denying, man. That I'm not denying. man.
Then you have to, no. we
In
are
this
not
case, I'm not
concerned-
denying,
We
my
are
lord.
not concerned as to whether their demand is legitimate or not. We are not
Yes,
concerned,
yes.
Mr.
Yes,
Mr.
yes.
Khatunia.
Yes.
The fact as to whether clause 9 merely states that till whatever amount is demanded is not paid off, rightly or wrongly, you are to bear the establishment cost. That's all. You have to bear it. Can't help it.
The only reason, my lord.
I can only give you one liberty out there that they will make the proper verification. within a particular point of time. And whatever, and then you have to pay the establishment charges. I'm only on establishment.
Yes,
Let
yes,
us
this-
limit it now.
yes.
And if
they are-
it is found that there is some thing to be destroyed, they will destroy it on the basis of the chemical analysis
Exactly, madam.
report, and then lower down the amount, whatever. But as of now, it is not final.
Because they are not acting on it. That's why it is not.
Understood. That
They
is
are
why-
not acting on it, my lord.
I understand. That is why this matter should have been urgently placed by you at that point of time. Why are you sleeping? This happened in 2017. These orders are passed.
Yes.
We are in 2023. So you bear the brunt. You can't help
In
it.
2017,
You should have
my lord,
there are a lot of lawyers out there who keeps on asking this court, take up this matter. You should have done that. Why that exercise was not there, that we are bearing such expenses?
Regarding the contention of the petitioner, that if the unsaleable stock is disposed of as per the procedure, that he'll get a rebate in the levy, ad valorem levy that has to be paid. That is completely unsubstantiated because this is a levy under the old act. The act says that the point of levy is on manufacturing. Then they pick it up from the distillery or manufacturing on a bond. The bond says that we are not paying the excise levy now, but we undertake to pay it when it is picked up by a retailer. Now, the point of taxation, your lordship, point of levy was already on the manufacturer. Now, what happens to the goods in their custody, your lordship, during the period of the bond? For that, your lordship, the state cannot be asked to bear the burden, your lordship, because the established procedure which clause 6 refers to, that is the procedure only for destruction. If I learn it,
No. I'm only on this. The question that as of now, there is no finality.
There is no finality.
As regards the demand, as
Yes.
per what the petitioner says.
Yes.
The liability of the petitioner to pay the establishment
Yes.
charge continues.
Continue.
That is the entire gamut of the matter.
Yes,
But
Lord.
you have a second prayer. The second prayer is that their amendments should be issued for destroying the unused goods. For that, I'm giving the liberty to the authorities out there to take a call within a particular period and do the needful.
Yes, your lord.
Then they are saved. And thereupon, what demand or whatever may be. has
Yes,
to be
they are
done
saved
to
from
work
payment
out.
of the establishment charge. Yes.
But till it is not done, because you can't also keep these petitioners waiting
Yes.
that you don't finalize these things. And unless you tell them,
Yes.
that look here, nothing doing. The excise, you are to pay this particular amount, you have not finalized. If you don't finalize, how long they are going to do it? So the interest of justice would be kept out there. If these people are directed to the state authorities have to take a call.
Yes.
Just to finish this process.
Yes.
How
definitely.
much? How much time? You have the commissioner has already given a report which he is
Procedure
enclosed
number.
out there to his petition.
Yes, madam. In fact,
Because
madam,
one problem you have as regards the VAT, whether the VAT is leviable or not, you have to separately challenge it on the ground that this is not saleable goods, and where is the question of where there is no sale, the question of payment
of
does
it
not
doesn't
arise. But this court at present for the purpose of this has to construe that the amount is still pending.
Yes.
The proceedings are still pending.
Madam, may I just add one?
Please do add.
Now, what the problem, your lordship, referring to the clause 9, say that till the realization of that. Now, so far I am concerned with the matter, but your lordship will find here, what is that? We have to get rollover from the department also to the amount of about 70 lakhs. 70 lakhs, because your lordship will find what has happened. I'll just give you what are the levy, what has been given. I have just given a short start for that. Levy and VAT to be the payable by the demanded by the joint team. But the first, it was the joint team. The levy amount was about 4 crores 44 so and so paid. Is absolutely paid. VAT, this was the demand we paid. There's a pending.
That's pending. Thereafter, my lord, there's another subcommittee, my lord, one is saleable and unsaleable, my lord. The stock is there itself saleable. Now you kindly see the rollover. The last rollover is what? How the rollover it has been counted, my lord, how we have been calculated what the rollover is concerned, because of the taxes which what has happened, not only that, even the retailers and my lord, warehouse also, the wholesales. The government by order, they have dropped the the price of the liquor, reduce the price. Now, once the reduce of the price, pilots, the taxes also reduced because the taxes have come. So these are the taxes. We sold it in a lower prices. The taxes which are different, they have to roll over and have to adjust that, pilot. That is why there is a pending, pilot. It has been shown in spite of request made to the.
So you are saying this amount of 66 lakhs, 54,376, you are entitled?
Yes,
from them.
My lord.
Well, they will deduct it from the
Well,
establishment.
if they do it, we are ready to pay all these things, pilot. We are ready,
not having
pilot. My lord, first of all,
Okay,
pilot.
let that verification
Yes,
be done.
yes,
If
yes.
there is an amount they are
My lord,
entitled to,
of course,
they
my
will
lord,
be entitled
of
to.
course, yes, pilot.
So that's there, but that does not foreclose because you see the main repetition is the question involved is as to whether you are liable to pay the establishment charge. We are not concerned with others. Have you made any prayer for destruction? No.
No, madam, I have not.
So
No.
your case does not involve a destruction, but his case involves destruction. So destruction has also to be done because if it goes on for unlimited period, it will be unreasonable for them.
My lord, where clause 6 is concerned, my lord, it has been specifically within 3 months, my lord. The clause 6 of this has been said. Now, from 2017 onward, now we are on 23rd. It has been, my lord, the joint committee, subcommittee day, everything, it has been kept aside, my lord. The huge-
No, first and foremost, when was the demand made to you?
My lord, 2018, my lord, 16 onward, my lord.
Okay.
We have
Now-
paid also. A
Now
part
the
we have paid,
demand
my lord.
when it was made initially
My lord.
by the excise committee, does it also take into account the subcommittee in that notification?
My lord, what has happened? I'll just
No, we are not on those. If we have to follow, you want the strict interpretation of the particular officer that the government order, then it has to be on the basis of that. Now, if you are saying that within 3 months this has to be done, very well. But clause 9 say that the establishment charge you have to pay till you don't pay. Till you don't pay that.
Yes, my lord. Till we don't have. Now, what is the problem which arises, particularly in this case, series of cases? My lord, after the new rules has come into the force, my lord. Now, prior to that, it was a the post-paid bill. Now it's a prepaid bill. Now, the not saleable goods has been assessed that these are the liquor which was not saleable. So they have kept aside the liquor, my lord. The taxes which are to be, what they have shown, my lord, on last occasion, my lord, my junior has pointed out me that these are the fact area which has been shown to the court was inclusive of non-saleable items, my lord. My lord, that is why, my lord, so dispute arises, my lord. We are also, what your lordship has said, so far the clause 9 is concerned, we are liable to pay so and so much. But what is the fault of the government, my lord? Excise department, my lord. The excise department from 2017, they have completed everything. Thereafter, they have not damaged us this. They have not excluded that.
But there is no prayer for you all for damaging.
No. That's it, my lord. Why the establishment charge they will ask for that?
From you because of clause 9.
Clause 9, but what we have said that
clause 9 specifically says
yes,
that you are to pay till it is cleared. Now, the fact that if you have cleared it, that ends. What is your petition number?
My lord, 8463, my lord. 8463.
Yes. As per them, you are liable to pay 7 crores 64 lakhs 63,639
Yes.
as levy. But you have paid 4 crores 69 lakhs 23,095.
That is not correct, my lord. That what I have just now given a distinct, my lord. That is the fact. My lord, that is why, my lord, your lordship, my lord, But direct the government, my lord, what I say, my lord, you calculate everything, whatever I have to get adjusted, we are going to pay, my lord, immediately, my lord. We are not saying that we will not pay, my lord. The dispute is regarding, my lord, only because of not adjustable, my lord, not reasonable items, my lord. If they make it a, my lord, assessment, my lord, what have to be taxed and what has to be paid to us also, then we'll come to the conclusion, yes, we can give it
No,
immediately.
if you have any claims with the government will place it out there with the government. The government will take a call. But only thing,
No.
Mr. Bora, kindly listen one thing.
My lord.
The fact that you are liable to pay the establishment charge as it has not yet been, the proceedings have not culminated, there is no quarrel with that. Because they say that there is a demand, you say there is no demand. But be that as it may. I can give the liberty only to that extent that if upon verification it is found out that the amount which has been paid by you earlier was the amount which has already been paid, then you will not be liable for establishment charge. Because if the amount has already been paid by you, then the question does not arise. But if the amount has not been paid, then you have to liable, isn't it, Mr.
Yes.
Now, just for example, he was supposed to pay 1 lakh.
Not
He has already paid you 2 lakhs earlier. Thereupon, when you are holding 1 lakh from him, the question of he continuing to pay does not arise. But that will be subject to a verification being conducted by the excise department as to whether this is the amount, because you say it is 4 crores something, he says it is less. You say the amount is 7 crores, he says it is 4 crores.
Yes.
Okay, so that aspect, there is verification, you can do it.
Yes,
so let us dispose it of in the presence of everybody.
And my lord, your lordship may kindly just take it. And whatever, my lord, not only that, all the liquor shop are to get a refund of this. That also be your lordship may, because taking into consideration of all these factors. But regarding
What refund?
Well, they have to adjust because lordship kindly speaking. So far, when they have to pay us, they don't give anything. There are not a notification, nothing else, my lord, nothing. But once you increase,
you want a proper bill.
No, not proper bill. I'm not saying a proper bill.
They, Mr. Pranbura on the last occasion also said, then look here, what he is doing is on the basis of a WhatsApp message. Really don't do that.
No, I have shown you, but I have shown from my record only, Lord. It's from the
So
WhatsApp
now
message.
you properly do it. Just find out and you give them the notices properly.
There's another aspect, your lordship, because if any adjustment is due, that can be done for subsequent amounts which are due from the petitioner also.
No. You see, clause 9 says you are to relieve him of the establishment charge.
Yes.
If the amount has been paid.
Amount has been paid.
Now they say that I have paid the amount.
Yes, that will help. Yes.
In fact, I am, on the other hand, we are entitled to around 70 lakhs.
Refund.
Then can you keep on imposing upon them
That is.
Then it won't be reasonable. Okay. Heard, Mr. Yes.
One observation from my lord that I have paid, yes, we have paid money in 2017, and they are not doing a destruction. They are sitting over the matter, my lord. They are not acting on the clause 6, my lord. Because of that, my lord, they are placing the establishment on us. If they
not on clause 6.
Exactly, my lord.
Clause 9.
No, the problem arises because of you have not challenged this excise commissioner notification order.
That I admit, my lord.
That is the biggest mistake you have done.
Is because my lord, they cannot levy tax without any rule, my lord. This notification.
I think somewhere some problem is there. I don't think it is mine. Not mine.
Because my lord, they cannot levy ad valorem levy and VAT, my lord, without any authority of law, my lord. Because that 29/8/2016 notification, by way of a notification, they are implementing an act which is came into force on 1/9/2016. That they cannot do. But that was not challenged before this honorable court, my lord.
Understood. That you have a case out there, you can very well challenge that notification.
Exactly, my lord.
On
That
the
was not
ground that
done.
that notification is no law. But you have agreed to.
Yes.
In fact, they want enforcement.
We have agreed to and we have paid also, my lord.
They're
We are
claiming
not
for rights
agreed
which
because
flow from that notification. They're claiming rights which flow from that notification.
because we,
Foundation of the
because we
case
have
is
not
that-
challenged it, my lord. Because we have not challenged it, my lord. That's why
You have accepted that.
yes, we have accepted it, and they are not they are not acting on the they are not acting on a clause.
High time. These matters needs to be disposed of.
But that observation, my lord, that since 2017, they are sitting over the matter, and that's why they are demanding the establishment, my lord.
They otherwise an interim order. is
I
in
can
operation.
give one thing that since 2017, they are sitting over the matter, and as such, they should not insist upon it. What do you say?
But Lordship, that would
If I say that, it will be further more disastrous for the petitioners.
They are so interest of
Huh? Oh. You have an interest for provision.
They have a penalty provision.
we have penalty. We have a
In fact, in earlier occasion, they have imposed 300% penalty, my lord.
That too, that matters.
Yes, my lord.
That matters, they've set aside. You file appeal? No.
Lordship, no.
Matter. Chalo. Heard Mr. P. Bora, the learned senior counsel, assisted by a Wager Junior. So and so, appearing on behalf of the petitioner in WPC number. Your Mr. Bora is WPC number 8463/2018 and WPC number 653/2019
and one
and WPC number 1250/2019. Mr. N.J. Khatania, the learned counsel, appears in respect to the Baki Gita petition did you, huh? Item number 3, 4, 5, 6, 7, 8, 9, and 12. Okay. Sure. The issue involved in the present Batchelor petition is as to whether the respondent authorities could have imposed upon the petitioner the establishment charges in terms with clause 9 of the order of the governor dated 29/8/2016. Footstop. The facts in the batch next part, the facts in the batch of the instant with petitions are that the petitioners herein prior to 1/9/2016 were licensed bonded warehouses. However, prior to coming into effect of the Assam Excise Act 2016, with effect from 1/9/2016, an issue arose in view of the change in the status of the bonded warehouse as it was defined in terms with the Assam Excise Act 2016, for short, the Act of 2016. A perusal of the rules framed under the Assam Excise Act 2006, under the Act of 2016 shows that the term bonded warehouse has been defined in Rule 1A Roman 1A to capital A, Roman 15 small, Roman 16, to mean the premises or any part of the premises within a manufactory and or within a canteen stores depot warehouse approved and licensed for deposit or storage of spirit on which duty has not been paid. On the other hand, Rule 1A Roman 17 defines wholesale warehouses to mean those premises or any part of the premises approved and licensed for deposit or storage of spirits on which duty of the oblique levy has been paid and from where India-made foreign liquor may be supplied by wholesale. In view of the change of the definition of bonded warehouses in terms with the rules of 2016, which now require to be within a manufacturing, the petitioners herein in the present batch of the writ petitions, on the basis of the definition, could not retain the character of a bonded warehouse and came within the ambit of the wholesale warehouses. With the change in the character of the petitioner's business from bonded warehouse to wholesale warehouse, an important aspect came into being. In as much as in bonded warehouse, the liquor is stored or deposited without payment of the duty, whereas in wholesale warehouses, the deposit or storage of the liquor had to be with payment of duty oblique levy. In view of these changes, which were going to be effective with effect from 1/9/2016, the governor of Assam passed an order on 29/8/2016 A perusal of the said order reflects that a joint team constituted as per the government order shall take stock of all such transitional taxable underbond stock of liquor, oblique spirit, in the erstwhile bonded warehouses, bracket now wholesale warehouse licensees, bracket close, as on the date preceding the date of coming into effect of the Assam Excise Rules 2016, including the stock date of the rules of 2016, including the stock in transit, comma, the value of such stock as per the books of account, and shall calculate and record the government levies involved on such stock, including the ad valorem levy and VAT, as per the rules of 2016 and the Assam VAT Act of 2003 as amended. Clause 3A and 3B of the same order is being relevant is reproduced hereunder. It reproduced page 19 of the same. It reveals from the said order, said clauses, that on the basis of the report to be submitted by the joint team, from the head of the joint team, the excise commissioner shall pass an order to the effect that the entire amount of ad valorem levy involved on the transitional taxable underbond stock of liquor be deposited by the licensees of the erstwhile bonded warehouse, bracket, now wholesale warehouse licensees, bracket close, at the rate applicable under the Act of 2016 within a period of 3 months from the date of coming into force of the rules of 2016. Further to that, in terms with clause B of Rule 3, on the basis of the said report by the joint team, head of the joint team, the Commissioner of Taxes shall also carry out a similar endeavor. Rule 4, under clause 4, rule 3 now, clause 3, huh? Sub clause A and B will go, no? Huh. Clause 4 of the said order dated 29/8/2016 further stipulates that the superintendent of excise of the concerned district shall submit daily report to the excise commissioner and the commissioner of taxes, along with the copy to the concerned superintendent of taxes showing warehouse-wise amount of area ad valorem levy and VAT realized on that day. In terms with clause 5, this entire amount of ad valorem levy and VAT on the transitional taxable under bond stock of liquor were to be realized within 3 months from the date of the notification of the rules of 2016. It was further mentioned that if any erstwhile bonded warehouse, now, bracket now, wholesale warehouse licensees fail to deposit the entire amount of area ad valorem levy and VAT within that period, the warehouse license shall be cancelled, liable to be cancelled, and the stock therein shall be liable to be confiscated to the state. Clause 6 of the said order dated 29/8/2016 is also pertinent to the instant issue. Inasmuch as the said clause relates to the presence of unfit or dead stock found in the erstwhile bonded warehouse, now wholesale warehouses. The said clause, being relevant, is reproduced hereunder. In terms with the said clause, it would therefore be seen that as regards the unfit or dead stock, the same has to be dealt with as per the established procedure on specific report from the head of the joint team to the excise commissioner and the commissioner of taxes on case-to-case basis within this 3 months period. While clause 6 related to unfit or dead stock, clause 7 related to godown or storage wastage allowance, which were directed to be allowed as per the established procedure on specific report from the head of the joint team to the excise commissioner and the commissioner of taxes on warehouses to warehouse basis within this 3 months period. Clause 9 of the order dated 29/8/2016 is the genesis of the entire litigation. Clause 9 of the said is reproduced hereunder. A perusal of the clause 9 shows that the excise establishment posted at the erstwhile bonded warehouse, now wholesale warehouse licenses, shall not be withdrawn till the entire amount of ad valorem, area ad valorem levy, and VAT on transitional taxable under bond stock of liquor, including the stock in transit, so deposited. The transit is deposited, and the licensee concerned shall be liable to reimburse to the government, the salary, etc., of such excise establishment till they are withdrawn by the government on a no dues certificate issued by the concerned superintendent of excise or deputy superintendent of excise and the concerned superintendent of taxes. It is in view of clause 9 that the petitioners herein in the present batch of writ petitions have been imposed have been directed to pay the establishment's charges which have been assailed in the instant writ petitions. Before further proceeding, this court would take note of clause 6 of the from a perusal of the writ petitions, it is the specific case of the petitions that the petitioners have paid the ad valorem levy as well as the tax VAT on the saleable goods which were fit for human consumption. It is the further case of the petitioners that as regards those unfit or dead stock, the respondent authorities were required to take up an exercise in terms with clause 6. And there are reports of the chemical analysis to the effect that those stocks were not fit for human consumption. And as such, the question of imposition of any levy on account of ad valorem excise duty or for tax or for VAT did not arise. And as such, the question of it is therefore the case of the petitioners that upon payment of the total excise duty as well as the VAT on the saleable goods, clause 9 of the order dated 29/8/2016 stood complied with, no, clause 9, clause 5 of the order dated so and so stood complied with. And as such, there was the requirement of payment of excise duty and as such, the payment of establishment charges in respect to those excise establishment posted in the wholesale warehouses of the petitioner did not arise. The learned senior counsel appearing in WPC number, which one, in which case you have more money?
846.
That in only in that case. Other cases, no.
Other cases also there, but I don't have the exact amount. The 846 I have
The learned senior counsel appearing on behalf of the petitioners in WPC had further submitted that pursuant to the reports was submitted by the head of the joint team, there were further subcommittees formed to decide to ascertain the amount on account of amounts payable on saleable goods and those which were unfit for human consumption. It is the submission of the learned senior counsel that in pursuance to the said amounts, pursuant to the said verification being carried out by the subcommittee, the petitioners on the other hand were entitled for recovery, for refund of certain amounts from the excise department, as well as from the excise, only from the excise department, as well as from the tax department. And as such, the question of imposition of excise, imposition of establishment charge in terms with clause 9 cannot arise in respect to such petitions. Next. This court also finds it relevant to take note of the submission of Mr. N.J. Khatonia, the learned counsel appearing on behalf of the petitioners in the other petitions wherein he had submitted that on one hand, it was demanded in terms with the order dated 29/8/2016 to complete the entire exercise within a period of 3 months. But till date, the respondent of excise department have not taken any action pursuant to the report submitted by the chemical analysis that these goods, certain goods, were not fit for human consumption. He therefore submits that the delay in bringing to end the proceedings was due to the fault of the excise department. And for that reason, the petitioner couldn't have been put could not be made liable for payment of the establishment charges. He further submitted that there is a prayer in his writ petitions, in all the writ petitions, for a direction to the respondent authorities, excise department, so that they act on the basis of the chemical analysis report and destroy and pass appropriate orders for destroying the liquor, the unfit and dead stock. I hope all your things have been covered.
Except,
Yes, Mr. Bora doesn't finish.
no.
I'm coming in 5 minutes.
I have a copy.
I found it somewhere. Somewhere it got lost.
It's in item number.
Oh, got it. I think I'll get it here. Had produced an instruction dated 29th of April 2023 of the Additional Commissioner of Excise, wherein the details of payment of ad valorem levy and VAT by the petitioners have been duly mentioned. Taking into account the said details, this court finds it relevant to incorporate those details in the instant judgment to the judge in the judgment. In the instance, exot যোনটো আছে এইখিনি ডিটেইলছ খিনি ভালকে চাই মেলি হা এটুত কিমান আছে এইবোৰ বহুত কোটি কোটি টকা দিছে Okay. It is therefore the case of the learned standing counsel for the excise department that as the petitioners have not cleared the entire dues in terms with the orders being passed by the excise commissioner, the question of not payment, not clearing the liability towards the establishment cost does not arise. In view of the clear mandate to clause 9 of the order dated 26/8/2016. The Learned Council, Standing Council for the Excise Department further submitted that the orders passed by the Excise Commissioner regarding payment of the ad valorem levy has not been put to challenge in any of the proceedings. Neither that order passed by the so-and-so, nor the clause 9 of the order dated 26/8/2016 has been put to challenge. Under such circumstances, till the levy remains unpaid, the petitioners are bound to pay. And the respondent excise department is also justified to demand the said amount on account of establishment charges from the petitioners. Anything else? I've heard the learned counsels for the parties and have also perused the materials on report. Before further proceeding, this court also finds it relevant to take note of that there are additional affidavits filed today by the various petitioners.
Affidavit in reply, man.
Huh?
Affidavit in reply.
Affidavit in replies filed by the petitioners. From the said affidavit in replies, it transpires that the petitioners have claimed that they have paid their dues on the goods which were fit for human consumption, and as regards the dead stock, even the Commissioner of Excise have also written it to the government for the purpose of waiving of the ad valorem levy and VAT involved in non-consumable stocks. However, it appears that on 27th of October 2020, the Undersecretary to the Government of Assam Excise Department after making a reference to the Finance Public Taxation Department of the Government of Assam, have issued an communication dated 27th of October 2020, stating inter alia that the VAT involved in the non-consumable stock amounting to rupees 18 crores 21,71,547.06, being a substantial amount, the same cannot be granted exemption as it would put a considerable strain on the state financially. However, there appears to be no orders being passed by the government in respect to the ad valorem levy of excise. In pursuant to the communication issued by the Commissioner of Excise to the Additional Chief Secretary to the Government of Assam Excise Department dated 29th of August 2019. Next. From a perusal of clause 9, এই প্যারাগ্রাফটো আগতে দিব তার পিছত I've heard the learned counsels for the parties and have perused the materials on the code তার পিছত এই লাইনটো এইটো আছে তার পিছত আহিব এতিয়া From a perusal of the clause 9 of the office order dated 29/8/2016 is clear and unambiguous. To the effect that the ad valorem levy and the VAT on the transitional taxable underborn stock of liquor, including the stock in transit, is deposited. The petitioners who are now wholesale warehouses were liable to pay the excise establishment charges. The fact that in pursuant to the report submitted by the joint team, the excise of commissioner have passed orders in terms with clause 3 is not in dispute, nor such orders have been put to challenge. The details were given by the learned standing counsel as detailed out supra in the tabulated form also makes it clear that there is a liability as regards that makes it clear that in terms as for insofar as the respondent excise department is concerned, there is a liability to pay the ad valorem excise duty as well as the VAT. The fact that the government of Assam in the excise department have not taken any decision on the dead or unfit stocks can also be seen from the affidavit in reply filed by the petitioners. The fact that the government of Assam in the finance and taxation department is also not willing to forego the VAT on the unfit or dead stock can also be clearly seen from the order dated 27/10/2020 issued by the commission under secretary to the government of Assam excise department, which is also not put to challenge by the petitioners. Therefore, from a perusal of from the above aspects of the matter, one aspect of the matter is clear. From the above, one aspect of the matter is clear. That the demand towards excise duty, excise duty, as well as the VAT have not been paid as demanded by the authorities concerned in exercise of the powers under clause 3 of the order dated 29/8/2016. Under such circumstances, as clause 9 of the office order dated 29/8/2016 is not a subject matter of challenge, the petitioners therefore would be liable to pay the excise duty, establishment charges till payment of the amounts so demanded by the authorities concerned in exercise of the powers under clause 3, or such demands are set aside in accordance with law. Next. The next issue which arises in view of a prayer being made in all the writ petitions is for a direct writ in the nature of mandamus directing the respondent authorities for passing appropriate orders by the respondent authorities for destroying the unfit oblique the dead stock It is the case of the petitioners that these aspects of the matter ought to have been done so within a period of 3 months. But till date, even after a passage of more than 6 years, nothing has been done, and thereby the demand so made upon the petitioners have not yet been, could not be brought to a so made against the petitioners. Continues to remain pending. Mr. Pran Bora, the learned senior counsel, as well as Mr. N.J. Khatonia, the learned counsel, has vehemently argued that the delay in taking a decision in respect to that, in respect to the dead and unfit stock, had made the imposition of establishment charge for no fault of the petitioners arbitrary and unreasonable, and thereby violates the mandate of Article 14. It is therefore their submission that these aspects of the matter needs to be decided by the respondent authorities at the earliest, so that the petitioners herein are not put to further harassment on account of their unreasonable demands. I've also, upon perusal of the materials on record, it transpires from the fact, it does not transpire that the responding authorities have taken any action as regards the dead oblique the unfit stock which have been mentioned in the report submitted by head of the committee in head of the joint team in terms with clause 6 of the order dated 29/8/2016. This aspect needs to be finally decided by the respondent authorities, more particularly by the respondent authorities, finally decided by the respondent authorities at the earliest, so that the entire exercise which was carried out in terms with the order dated 29/8/2016 could be brought to a logical conclusion. Therefore, this court directs the responding authorities to take a definitive decision on the claim of the petitioners in respect to the dead oblique unfit stocks within a period of how much?
3 months.
2 months.
Because the other petitioner lordship had directed that we must conduct an exercise.
Other petition I have directed you either serve him an excise from the BIU's inspection report or go ahead, or I have given you, you can go ahead with and further make search. That is a different thing. So that is a different aspect. You have to finish on the dead stock within 2 months.
Because there also the issue of dead stock would be there, Your Lord.
Understood. That is not the question in that case. That case was a question of natural justice.
Yes, on the ground of natural justice.
That order was passed in the month of February.
So I give them 2 months. In 2 months from the date, a certified copy of the instant order is served upon the Excise Commissioner? Commissioner of Excise. First. Next. A further submission has been made on behalf of the petitioners, more particularly by Mr. P. Bora, the learned senior counsel, to the effect that in the case of the petitioner in WPC number 6141/2000,
In my item was one item number 4, I have annexed the document where they have admitted that they're liable to pay some amount.
Okay, then I will put it like this. A further submission has been made by the learned counsel for the petitioners that pursuant to the reports were submitted by the head of the joint team, there were certain subcommittees formed for the purpose of verification as regards the unfit oblique the dead stock, and the verification as regards the excise duty, ad valorem excise duty and VAT, by bifurcating those saleable stocks with unfit and dead stocks. It is the case of the petitioners that pursuant to such reports so submitted by the subcommittees, some of the petitioners are entitled to refund.
Not exactly subcommittee, my lord, because after that, my lord, there is a difference of price. Due to COVID, they have increased the price, after they reduce the price, my lord. Because
COVID
of,
happened in 2020.
yes, my lord. Because of
Inspection was done in 2016.
yes, my lord, this rollback amount, later on, my lord, we have paid a more amount, my lord, due to increase of
Perhaps
pay.
that is not the prayer in this petition.
This is not
Perhaps
a prayer,
it
my
is
lord.
No.
But there-
I am saying that I'm making it clear to that effect that there are certain amounts. On the other hand, the petitioners are entitled to recovery of some amounts. That is your submission. It is therefore the submission of the learned counsel for the petitioners that the respondent authorities, more particularly the Commissioner of Excise, shall also be directed to take note of those aspects of the matter while demanding the establishment charge. Considering the above, the instant writ petition therefore stands disposed of with the following observations and directions. Instant writ petitions. Number 1. The petitioners herein are liable to pay the establishment charges in terms with clause 9 of the order dated 29/8/2016 till payment of the ad valorem excise duty as well as the VAT. On the basis of the orders passed by the authorities in terms with clause 3 of the office order dated so and so 2016. Till such time the said amount are not paid or such amounts so demanded are not set aside in accordance with law. Number 2, the respondent authorities and more particularly the Commissioner of Excise is directed to decide the question of is directed to take a decision, definitive decision in respect to the unpaid and dead stocks lying in the godowns, in the warehouses of the petitioners within a period of 2 months from the date a certified copy of the instant judgment is served upon the Commissioner of Excise. Number 3, the petitioners would be at liberty to place such materials before the Commissioner of Excise to show the petitioner's entitlement to show as regards the amounts the petitioners have paid and if during such verification it is found out that the petitioners had already paid the amounts in terms with the demands so made under clause 3 of the order dated 29/8/2016. Then from such date, the petitioners would not be liable for the payment of establishment charges. On the facts of the case, this court is not inclined to impose any costs. Yes, Mr. Das, your matter. Mr. Nair, you are taking up the preliminary objection?
My lord, I will. But
Number 15.
I'll satisfy your lordship on the merits of the matter.
No, no.
And I'll place.
Well, if it is, you are going, first of all, you have to decide as to are you taking the preliminary objection?
My lord, I am taking the preliminary.
On the question of jurisdiction.
Jurisdiction. One.
If you are taking it, then let us first look into your submission then I will ask him to rebut.
Only on the last occasion, the order specifies that my learned friend had informed the court that he will take a call. On the court, the governing body sat.
What happened with the governing
My lord,
body?
the governing body had sat on 4-5, my lord. And thereafter, the governing body came to a conclusion after discussion of the examination of the replies submitted. That's not satisfactory, and they have proceeded with the inquiry. And the inquiry has been directed to be completed within a period of, my lord, I think 30 days.
30 days.
30 days. Back to back, and thereafter finish the whole thing. Because she's a principal. She's the principal of the school. My lord. Keeping her hanging also is not proper. So
I hope what you are saying, all the counsels for the respondents hear that, not to keep hanging people.
That's true. That's true.
Anyway.
It's not good for us also.
But anyways, let us.
My lord, before I,
Mr. Das on the last occasion submitted that, be that was it may, you may take a decision, is a different aspect.
Different
of the
aspect.
matter, but first of all, he has a good case on malice on fact and malice in law. But anyways, we'll go into that later on. First,
my lord, first I'd like to, my lord, address your lordship with regard to that issue of suspension. My lord had asked me that, what is this 30 days, how it has come up, and all those things, my lord. If I can just take 5-10 minutes and just place those what I have got, my lord, thereafter I
Yes,
go.
yes, please do.
My lord, there are two aspects here, my lord. What I have found, my lord, from the word go, the old, my lord, central, those FRSRs, I could not lay my hands on. My lord, there are provisions for suspension. And there is a provision for dealing how the person would be paid during that suspension. Two things are there. Now, Ajay Chaudhary only did was picked up 167.2 and then applied it 60 and 90, my lord, made it 90 and then applied it. But this 90 concept is there for payment of review for payment of subsistence. Now, my lord, as far as I have read, it was 1 year before that. Then it became 6 months. That 50% will continue till 6 months and thereafter. In 1981, the FR, central FR was amended and it was made 30 days. Consequently, the state 30 days. That 30, no, sorry, 90 days, 3 months for 90 days. And that amendment was followed in the state also. So, my lord, logically speaking, all this, my lord, goes back to the 73 CRPC Code of Criminal Procedure 73, because 81, that amendment, I don't find, my lord, anything else to logically support that 90 days concept. It was maybe picked up or, my lord, adopted, although the Supreme Court said that it's doing it for the first time, but the authorities, it seems, my lord, had adopted that from the CRPC. Because, my lord, what happens is 90 days, if the, I'm just using, if the, my lord, charge sheet is not filed, then, my lord, he automatically gets a default pay. And that same very concept is there after Ajay Chaudhary. So 90 days, 3 months, you don't give that show cause. No, it's not that he should be kept in suspension for 3 months together. You can issue the show cause within 15 days also, 10 days also, or on the 89th day. It depends on case to case. So if it is not issued, that suspension order does not exist, as far as my understanding of para 21. But if that is issued, then there has to be an order extending that period of suspension in a given case if it is required for conclusion of the proceeding. So 90 days is the time limit that the authorities have to collect materials to come to the definite conclusion of the suspicion they had about the person. I'm talking about 6-1, but if a criminal case stands on a different footing. So within the 90 days, they have the time frame to collect those materials required, because the materials may be in his possession. He has to be moved out, get the materials collected, and within that 90 days, he has to be given the show cause, my lord, or the memorandum of charge. If not given, then my submission would be that the suspension order would not, after that 90th day, it would not survive. And my lord, a review of that suspension order in a case under 6-1 of our rules, my lord, will not be permissible. My stand would be that. But if you have given a show cause, a notice to that person, whereby, my lord, you have communicated to him the reason for his suspicion, or the suspicion that was there, which led to the, or apprehension that was there, or the prima facie satisfaction that was there, that he might have committed something, you have now communicated to him that these are the grounds on which we will. He still can challenge it, but it will not be automatic. The suspension order will not go away automatically. There has to be a proceeding either before the appellate authority or before my lord. And then your lordship would examine the matter and finds that the suspension may not be required after this process. My lord can always interpret. And why, my lord, this another aspect angle to look into this is, say, my lord, earlier prior to 1973, as the, my lord, the criminal procedure stood, 15 days, the magistrate could extend the period of, my lord, detention. There was no outer limit given. Outer limit came because there should be a definite thing. 90 days, my lord, in an inquiry, the investigation can be done properly and the thing can be. Now, what happens when a man is placed under suspension? The Supreme Court in that last set said that speedy trial, all these things also is equal to a right to liberty. It has put it in the same pedestal, para 20. But when a person is placed under suspension, although it has been said it's not a punishment, but he faces some problems. One, he will not be given any increments. During that period, if an increment is due, that is not accounted for. It is kept pending until and unless a decision on conclusion of the proceeding is taken under FR 54. That the period of suspension would be dealt with in this manner. If it is on duty, he gets back everything. And if it is not, then, my lord, it has to be dealt. It's a different aspect. There is still a gray area whether at that point of time a notice has to be given to him. That's beyond this. Now, basically, when a person is placed under suspension, my lord, the Supreme Court has said it's not a punishment. And, my lord, that thing that he has been, if subsequently there is a proceeding initiated against him, charge sheets have been framed, there are materials which have been produced before him. So the suspension does not get, my lord, validated by that issuance of the show cause. But the placing of a person under suspension to some extent gets, my lord, validated, subject to your lordship saying that there was no material at all. That's a different factor. Now, my lord, upon a person being placed under suspension, my lord, he cannot be considered for promotion. That would be a part. In addition to, my lord, what is there in Janaki Raman, that on initiation of a departmental proceeding, a person's case will go to seal cover. Similarly, my lord, there are DOPT guidelines which say that even CVC guidelines are there, which says, my lord, that a person is under suspension. His case, he will not be promoted. Be that as it may, whether the, my lord, charge sheet has come, not, that's a different issue altogether. But within that period, when it is permissible to keep a person under suspension, if his case is to be considered for promotion, it will go to seal cover. He will go to seal cover. He will not be promoted. So that's another, my lord,
That is the CBC guidelines.
CBs are there and the government also has guidelines to that effect. So these are the aspects, my lord, which my lord, literally, my lord, they say that the period of suspension should be the minimal anytime. Now, my lord, I was seeing from the angle of the criminal proceeding. When would this 90 days literally begin? What I found is, my lord, hypothetical situation. Say, my lord, I am arrested in case A, and I am behind bars. And while being behind bars, that 90 days period is coming. There is another case, my lord, where I am shown arrested. I continue to be under suspend, behind the bars. I am not detained twice. I am detained only once. 48 hours is over. But because of this subsequent shown arrest in another case, I, my lord, continue to be in detention beyond that period of time. Now, I come up to your lordship. Say I am released. In that case also, I get a bail. Say, my lord, after 30 days, I come up before your lordship and say that my 90 days had, in case A, when I was under detention, my 90 days is over. So I should be now reinstated. Following, let's say, my lord, in criminal case also, Ajay Chaudhary applies. I should be put back. In that situation, my lord, I question myself, what would be the way out? My understanding of the issue is, the day he gets paid, and that is communicated to the authorities, that would be the day when, my lord, this 90 days thing would start.
I've given a judgment on that.
My lord,
I've given a judgment on Rafid Ali on that because my basic understanding is
Lordship.
Rule 6(2)
Lordship.
says a person, the moment he's arrested or kept, the word's use is not arrested only, he's under detention.
Detention.
And in any manner. So if he is in detention in any manner, he will continue to remain in suspended. That is the embargo of a procedure, of a statutory rule.
Lordship, 6(2).
And being so, unless that rule is not set aside, a Supreme Court judgment may be there on whatever it may be, but then also the rule has to be set aside. And if it is rule is not set aside, then he cannot be brought into the service after completion of 90 days if he is inside.
That one.
And secondly, how do you take care of the proviso to Article 311? How do you give him a proper, what you call, reasonable thing that you want to so curse him? You are giving him, you cannot do so without an inquiry. Now, this inquiry, you are asking him to, first of all, how will the authorities serve him there? And apart from that, what is would it be reasonable for him to reply from there? So that aspect of the matter I've dealt with.
My lord has that. I faced a similar problem, my lord. I faced a similar issue. But although, my lord, it did not, I'll have to read that judgment, not go into that details. There was a detainee, a famous detainee, my lord, in the chain, the NCL's case.
In fact, this law, which I laid down, I made it that although the proviso to Rule 6(2) stipulates 3 conditions, but a 4th condition comes in view of the law laid down in Ajay Chaudhary and Rakibuddin. And the 4th condition is the moment you, upon a person being outside the, not in custody, he submits a representation and within 3 months you have not given, then a right will accrue.
That's the way, my lord, it should go. That's what I have understood.
I have given that.
Because what happens, my lord, say my lord takes it 90 days. My lord, even my lord, give that benefit of doubt that the person can make a reply. Let's hope he makes a reply. But my lord, the proceeding, departmental proceeding, it's said to be a quasi-judicial proceeding. So the person has to be given all opportunity to defend.
No, I've dealt with that.
That I'll have to.
And not
then
only
my
that,
lord, it's settled. It's settled then. My
because-
apprehension goes.
Yes, because that is the only thing. No, I was saying, once you bring in 167 in a suspension,
Lordship.
now 167 have been thoroughly explained in Rakesh Kumar Paul's judgment by Justice Madan Lakur. Now, if you see in the penultimate paragraph of the same judgment, it says that he be released on bail if he is not required in some other place. But he may be arrested again. And in that case, he will be entitled to go on regular bail by filing appropriate application. Now, how do you therefore, and from there, another aspect comes in. If you bring Ajay Chaudhary, how do you read Ajay Chaudhary? That is what I was just thinking.
Malad.
Ajay Chaudhary says a 167. No quarrel. 90 days is over, you have to do it. So your right to get reinstated would be from the 90th day, after the 91st day, if they have not given you. But that right will only continue till they don't serve you the memorandum of choice.
And they can
Now
place-
again go back to 167. If in the meantime the charge sheet is submitted, your valuable right under 167 goes.
No default bid.
So therefore, that is how paragraph 22 comes in Ajay Chaudhary. He says, it is mentioned, now in the instant case, he has already been given this. Unless such the principles above would
Will
not
not
apply.
My lord, there is a reason for that also. If my lord reads the paragraphs earlier, when the case proceeded from the Central Administrative Tribunal to the High Court to the Supreme Court, my lord, therein, the Ajay Chaudhary's this final para 21 was not there. So the earlier system of my lord going with reviews were there. So the case, in his case, it was being reviewed regularly. It was being reviewed regularly, and it was in pursuance to one of such reviews. When the suspension period was extended, my lord, it was in that interregnum between that review and the date till which it was to continue, the charge sheet had come in. So, in all probability,
If you read paragraph 22, it says,
Lordship, I know it, but if my lord reads 22, it says you go for the regular bail now. If I may just use that word.
Just read it.
So far as the facts of the present case are concerned, the appellant has now been served with a charge
So
sheet,
now being searched.
Lordship, and therefore these directions may not be relevant to him
So
any
this
longer.
happens to be during the pendency before the High Court Supreme Court.
My lord, however, if the appellant is so advised, he may challenge his continuous suspension in any manner known to law, and this action of the respondents will be subject to judicial review.
So there again, it brings in the same regular bail concept.
But my lord, here, subject to my lord, what my lord would finally say, if my lord comes to the factual matrix of this case, which my lord in paragraph 2, thereafter, the third extension of the appellant suspension was ordered on 21/12/2012 for a period of 90 days. It was to be followed by the fourth suspension, yet another period of 90 days with effect from 23/3/23. It appears that the tribunal gave partial relief to the appellant in terms of its order dated 22/5/2013, opining that no employee can be indefinitely suspended. That disciplinary proceedings have to be concluded within a reasonable period. CAT directed that if no charge memo was issued to the appellant before the expiry on 21/6/2013 of the then prevailing period, the appellant would be reinstated in service. This, my lord, went up by the
Delhi High Court.
Delhi High Court.
That is why there was no charge sheet given.
No charge sheet. My lord, then what happened is,
Charge sheet was given at the time when the matter was pending before the Supreme Court. And
Lordship.
therefore, the Supreme Court says that now as you have got it, the same principle will apply.
there is one fact, my lord, para 5, wherein it says, this led to the filing of the appeal before this court. In the hearing held on 11/7/2014, it is noted by the letter dated 13/6/2014 that the suspension of the applicant has been continued for a period of 90 days with effect from 15/6/14, and that investigations having been completed, sanction for prosecution was to be granted within a period of 2 weeks.
This
Para
is the
6.
criminal one.
Criminal one.
There is the criminal one, but the charge sheet was only given there.
Charge sheet, my lord, in the criminal case, there was no charge sheet.
Here, the charge sheet which is being referred to in the memorandum of charge at para 22 is for the departmental proceedings.
My lord, maybe, but my understanding of the thing was, my lord, that here the charge sheet.
Not charge sheet, because then obviously a person may, if we understand the same to be the charge sheet, then obviously the problem will be there.
167(2) should have come in, my lord.
Yes.
But I think he was on bail at that point. in time. But here, what I have
But
understood.
not only that, that means if a person is being, you see, the word used in paragraph 21,
Lordship.
a charge sheet is served upon him. See, how can you charge a charge sheet under 178(3), 173(8) be served upon him? You can't serve a charge sheet in the criminal proceeding.
No, you can't.
But this, when they use it with a hyphen,
They mean both.
it's actually they mean the same. The memorandum of charge. So that was not done. That is how you read this.
My lord, here,
Now
although,
I am
yes,
further developing. I am further developing on this thing that if you give, because now in the meantime, Ajit Sonwal's judgment has come before by the division bench, wherein it says that you have to, even after deemed suspension also, you can then again suspend him under 6(1). Now, if that is done, the entire meaning becomes useless. So what is to be done is, therefore I asked you about the 30 days, 90 days. The 90 days, you have to read it again with 2.18 of the manual. Now in the manual, you see, it is not, you have to understand that this 90 days concept has been brought in view of rule FR 53. Now FR 53 categorically mentions to the effect that initially the period of suspension will be the subsistence allowance will be for 3 months.
3 months, 50 months. And that came in 81.
So it will be for 3 months. Once it happens for 3 months, that is the reason why. Because it is normally believed that you are to complete the suspension period within 3 months and complete the departmental. Therefore, if you see FR 53(2) and more particularly A and B, then there is a call which one has to take. That if it is because of a delay being caused by the delinquent, he may delay. Then under such circumstances, you have to reduce the subsistence
25% increase or 25% reduce.
You can reduce it because of that.
Yes, Your
if there is a person concerned. So therefore, from 3 months onwards, it has to be seen that both of them keeps on starting or doing the matter together as soon as possible.
And my lord, this 3 months is the maximum. That 3 months thing, my lord. The proceedings can.
It is conceived of that within 3 months you do, because you are only paying 50%. But once you start paying him 75% and there is no work, does it make any sense?
Lordship. That's why
I shall be more happy with the 75%.
Paid holiday, as I call it, my lord.
Anyways, come to the point here.
Lordship. So, my lord, the suspension, I got what if that judgment, I'll have to just go through once, my lord. I think that answers my queries. Whatever was troubling me, I think it's been already answered. I did not deny you a lot.
No, in fact, yesterday I was taking up one matter.
Lordship.
It's also a very interesting matter. What has happened when Mr. Ken Chaudhary was there, on the other end, Mr. R. Dhar was there. Here is a case, a person concerned has been put on the suspension. He has not been charge sheeted. All other people have been charge sheeted, everything. Now, in the memorandum of charge which has been given, there are 4 witnesses. Out of 6, 4 witnesses, we are in judicial custody. Now they say we are completing within 3 months. I asked you how? You don't have the power to summon witnesses. And if your witness can't come in near future, unless you go before the CGM, because he's under the custody of the CGM, and say, look here, in order to put this particular person, have a departmental inquiry, kindly release them on bail. It's a different aspect, which they are now going to do. So under such circumstances, if the person has to be recorded, let us assume that this is from the Home Department, they can very well go inside the jail and do it. But can you ask the petitioner to go to the jail?
No. No,
This is another new thing which is.
it will be interesting, my lord.
Yes, what is the point on maintainability?
My lord, maintainability here, what I would like to submit before my lord is that my friend would be referring to the case of JB Law College, wherein my lord, the governing body was kept in abeyance and an administrator was appointed. With the plea that we are giving money to the college, so we have the power under the 2001 rules. So my lord, we can do it. This honorable court interfered with that and said nothing. My lord, I'll not trouble your lordship with the other judgments. The latest judgment is 2022 SSC Online, Supreme Court 1091. I think a copy. Now, this deals with, my lord, educational institutions. Now,
He used to work as the president of the governing body. What is, she worked as what?
my lord, she was the principal of the college,
Of the principal of the college.
lordship.
Okay. Now
She
the
was-
college
It's a private college.
is
It's a society.
college.
It's a private.
Only received the grant in it.
My lord, no. That again, my instruction is that they have given some money sometime, once something, 2013, some amount, paltry amount, some amount was given. Thereafter, my lord, there is no recurring payment made to this college. Now here, my lord, if I have understood this matter in its perspective, an employee of a private college, which was, my lord, governed by the CPSE regulations, my lord, was subjected to a disciplinary action.
Where?
Here, in this
Supreme Court.
Supreme
yes.
Court case. And thereafter, he was terminated.
Hmm.
He challenges the termination before the Honorable Single Judge. The Honorable Single Judge negates it. The matter goes to the division bench. The division bench takes a view that as the school or the institution is doing a public duty, it will be amenable to writ jurisdiction. Now, what the Supreme Court has said, that there is a distinction. That something which the school is doing, maybe it's governed by the CPSE regulation, or in our case by the Guwahati University regulations, that would be, my lord, if there is something in that, maybe a proceeding would be maintainable before my lord. But for service conditions between the college and the employer, contract of service, a writ for violation of that will not lie. If my lord can have para 3 men.
B.
Lordship?
B.
B. 3B. And then my lord, not trouble your lordship with that, para 35. It needs no elaboration. That a school affiliated to the CBSE, which is unaided, is not a state within the Article 12 of the Constitution. Nevertheless, the school discharges a public duty of imparting education, which is a fundamental right of the citizen. Para 35.
35.
It's 35. It would be page 12. It needs no elaboration to state that a school affiliated to the CBSE, which is unaided, is not a state within Article 12 of the Constitution of India. Nevertheless, the school discharges a public duty of imparting education, which is a fundamental right of the citizen. The school affiliated to CBSE, therefore, there is therefore an authority amenable to the jurisdiction under Article 2 to 6 of the Constitution. However, a judicial review of the action challenged by a party can be had by resort to jurisdiction only if there is a public law element and not to enforce a contract of personal service. A contract of personal service includes all matters relating to the service of the employee, that is confirmation, suspension, transfer, termination.
So here you are saying that this school,
Lordship.
this college,
Lordship.
is not a, maybe a state.
Maybe a state.
But for the purpose of the suspension of the person concerned, as more particularly as the person concerned is not regulated by any statutory. So therefore, it would not come within the ambit of rights
Under-
being violated,
Violated under Article 2, which will
which
permit him to
can be called in question
in a public law. It's a private law. Now, this finally, after discussing, my lord, all the aspects, my lord, paragraph 69 is the conclusion.
68?
68 and 69. 69. And there in one aspect here, my lord.
68 will be relevant.
Lordship, in the aforesaid context, we may also say that merely because the state government has a regulatory power, the same by itself would not confer on any such status upon the institution, nor put such obligation upon it which may be enforced through a writ, through issue of a writ under Article 2 to 6 of the Constitution. In this regard, we may refer to and rely upon the decision of this court in case of Federal Bank. While deciding whether a private bank that is regulated by the Banking Regulation Act 1949 discharges any private function, this court held as thus. In our view, a private company carrying on a banking business as scheduled bank cannot be termed to be as an institution or a company carrying on statutory or public duty. A private body or a person may be amenable to writ jurisdiction only where it may become necessary to compel such body or association to enforce any statutory obligation or such obligation of public nature casting positive obligation upon. We do not find such conditions are fulfilled in respect of a private company carrying on a commercial activity of banking. Merely regulatory provisions to ensure such activity carried on by a private body work within a discipline do not confer such in any such status upon the company, nor put any such obligation upon it which may be enforced through issue of a writ under Article 2 to 6 of the Constitution. Present is a case of disciplinary action being taken against its employee by the appellant bank. The respondent service with the bank stands terminated. The action of the appellant bank was challenged by the respondent by filing a writ petition under Article 2 to 6 of the Constitution. The respondent is not trying to enforce any statutory duty on the part of the bank. Thus, contracts of a purely private nature would not be subject to writ jurisdiction merely by reason of the fact that they are structured by statutory provisions. The only exception to this principle arises in a situation where the contract of service is governed or regulated by a statutory provision. Hence, for instance, in so and so, this court held that when an employee is a workman governed by the Industrial Disputes Act 1947, it constitutes an exception to the general principle that a contract of personal service is not capable of being specifically enforced or performed. It is of relevance to note that Act was enacted to provide for regulation and registration of clinical establishments with a view to prescribe minimum standards of facility and services. The Act inter alia stipulates conditions to be satisfied by the clinical institutions for registration. However, the Act does not govern contracts of service entered into by the hospital with respect to its employees. These fall within the ambit of purely private contracts against which writ jurisdiction cannot lie. The sanctity of this distinction must be preserved.
Show me her appointment order.
Lordship. My lord, it's at page 22 of the writ petition.
Now, yes, page 22, once a person is being appointed,
Lordship.
whether that appointment is not sent to the Director of Higher Education?
No, no.
No, not
No,
necessary.
no, not necessary. This is a contract between the, my lord, the governing body, which is the supreme authority, and the person concerned.
So this college does not come under the ambit of the higher education?
No.
It comes under which?
My lord, it is governed by the Bar Council of India and the affiliating universities regulations. Which,
So
my
the
lord,
salary is paid by whom?
by the self-financement, by the college itself, from the earnings it
Revenue.
makes from the students. We have to follow one thing, my lord. While appointing a principal or a teacher, the affiliating university, following the Bar Council of India guidelines, lays down certain parameters that these are the educational qualifications that a person should have. We must have that. That
But
person,
thereupon, don't you place it before the any higher authority
No,
once you appoint,
no, man. It's their
like it is required in respect to all college principals? or
principles
college
that,
teachers?
because those are principles governed by the statutory regulation. Any selection made has to go to the director with his approval, only the appointment can. Here, there is no such condition. I can get back to my lord. I'll just inquire, my lord. If that is there, I'll get back to you.
If I may counter, my lord, this is not the correct position. All decision has to go before the director because
Director of higher education.
yes, my lord,
Yeah.
because what has happened when the first statement or affidavit opposition filed by the respondent number 5 was not correct. It was a duty of the president to place the correct facts. He said that we don't get anything from the from the government. The government in 2013 specifically said that for a public institution which we are giving you 3 lakhs odd, I have given the letter, you give us compliance report or we'll take action against you because it's for a public purpose. The reason is that, in fact, my learned friend has confused the word Article 12 with other authorities. The other authorities is a far comprehensive term, and 226 power is not only for fundamental right violation, but also for other legal right, which can be common rights also. Common law rights is under the private law. And in fact, I'll distinguish the case just now referred by my learned friend.
Only thing is, see, all the other judgment is right?
Because he's talking on
Does your
maintainability.
appointment have any relation to by which any process is required to be done by the statutory authority?
Yes, because the non-government college rules has been brought in the JP Law College case. The non-government college rules and the university regulations are very much in force. In fact, on the last occasion, one thing has been missed out by my learned friend. Your lordship had asked for another query, that whether, because the question was that we are a society or private, and your lordship has rightly asked it, will you be without a remedy? The article of association that was supposed to be given today, possibly it's my duty to point. Well,
That was made by
they
her,
have
my
given.
lord. That was made by her, and therein there is a, with her name, when the first registration had lapsed, and during her tenure, the second registration, society registration was made. I have just got the documents with me. There is a clear undertaking given in her name. It said Smita Borua so and so. It's given by the president. She submitted it, wherein it is said that the government had never paid us.
In fact, Malato, the one thing I like to show, the article of association which they have to show, now I'll show from their affidavit. Lordship will come to their affidavit at page 54, where your lordship has put a very pertinent question, which finds reference with a Supreme Court judgment. The lordship will find that basically the rules and regulations are page 54. Your lordship will find towards the last serial 14. Is the affidavit in opposition by the respondent number 5? Can I read? Page 54 of their affidavit in opposition by respondent number 5. Expulsion of undesirable any member who goes against the rules and regulation of the organization may be expelled from the organization. Malad, he is referring to, because under the rules and regulation, the president refers that you are placed under suspension because it is not only dereliction of duty, insubordination, also on violation of the rules of the governing body. If it is so, it shows as per Guwahati University regulation. My information is that the Guwahati University regulation complies with the Assam disciplinary appeal rules. And in fact, an argument was advanced by my learned friend when the preliminary objection was taken that section 6 of the suspension starts from the date he was referring to, but he is not referring to that a show cause was issued on 28/3/23 to give a reply that show cause does not mean the commencement of the disciplinary proceeding. The disciplinary proceeding starts when the charge is given. Till now, no charge is given, and section 6 of the Assam Disciplinary Repeal Rule 64, sub clause 5 talks about a periodic review, which is a mandatory requirement. In fact, there are umpteen number of Guwahati High Court judgments which says that an order of suspension made or deemed to have been made under this rule, that is 6A, may at any time be revoked by the authority which is made or is deemed to have been made, the order by the authority which is not subordinate. Well, has the periodic review been done? It is only when my matter got fixed for
I
final
don't
hearing.
think 6.5 says about periodic.
Yes,
review.
well, it's a mandatory requirement. They are
But where does 6.5 say that? 6.5 says that they will take a call or decision to that. It doesn't say about
No,
review.
no, it talks about definitely. 6.5 talks about an order of suspension made or deemed to have been made under this rule may at times be revoked. Any time be revoked. Anytime means. No, yes, may at any times be revoked, but the reason is, your lordship.
No, we can bring in the concept of review from other places. There is
Yes,
no quarrel.
yes.
The power is there. Because I remember, because I was dealing with this particular provision when I was taking a matter pertaining to this particular judgment of Ravi by Supreme Court.
Yes, lordship.
In 1996 or that matter, wherein it has been said that because you see the CCS rules of 1965.
Yes.
They have a particular provision which is similar to ours, that is clause 10, rule 10. Now, rule 10 is also provides for deemed suspension, but there is a specific provision, 10.5a, which says that any deemed suspension order has to be revoked by a specific order. In view of that, a submission was made therefore that the automatic judgment in Ajay Chaudhary may not be proper because of this thing. But I have distinguished it taking into account that that would not apply because we don't have a parameterial provision.
Yes. And deemed suspension is not my case. Deemed suspension applies to criminal proceeding. It has nothing to do with, this is a departmental proceeding. In fact, the yardstick are different.
In that case also,
yes.
10.5a is in respect of the moment a deemed suspension is given, then also it has to be removed by a specific order.
Yes.
So unless that order, because there's submission was there before that court, was there is a specific order without what happened, the person was arrested and after he was released, then he was put under suspension. So he challenged as to why you didn't, but they say that you will deem from that day. And then further the Supreme Court says that look here, unless and until there is a specific order to that effect, you cannot have it. So that is what has been mentioned now. But anyway, that is another aspect. Here is the case as this, if your expulsion is as per the Guwahati University regulation,
which follows the 64 Act.
A temporary or an interim thing which they can do has also to be in terms with that Guwahati regulation.
Absolutely. And in fact, the maintainability part usually is now diluted for the simple reason that there is a constitution bench judgment. For the first time in India, the Kaushal's case, the Supreme Court has now brought in the concept of horizontal fundamental rights. In India, it was always vertical, state versus the citizen. Now it is state, citizen versus the citizens or non-state actors. And my argument is that
judgment where whether a person speaking, a minister.
A minister, yes. But in fact, elaborately, in fact, the judgment which the St. Mary's judgment I've gone through is not applicable to my case for the simple reason. In paragraph 28, 29, it talks about St. Mary's the judgment referred by my learned friend. It talks about Article 12, and it was a clerical staff, not a member of the teaching staff. So a clerical staff, the contract of personal service under the common law is available. But in my case, the judgment of the Supreme Court directly on this point on a private university, which came under a trust. the benefits was given by the single judge, not given by the division bench. Supreme Court says you place it, and the maintainability part is rejected because 226 is too big a power, and the private institution will definitely come in within the contours of 226. Because if not so, the person will never get any benefit because of arbitrary exercise of power. Well, this is para 25 is the relevant para 25, where another 1989 Supreme Court which goes in my favor, and para 15, if I may read, very relevant to my case. It squarely covers my case. Page 537. Paragraph 15.
2015, 16 SCC
15, 16 SCC 530. Paragraph 15, if I may read, Lordship. This ground was taken on maintainable. It was rejected. If the rights are purely of a private character, no mandamus issue. If the management of the college is purely a private body with no public duty, mandamus will not lie. These are two exceptions to mandamus. But once they are absent and when the party has no other equally convenient remedy, mandamus cannot be denied. It has to be appreciated. The appellant trust was managing the affiliated college to which public money is paid as government aid. Here, government aid is given to Tezpur Law College. Public money paid as government aid plays a major part in the control, maintenance, and working of an educational institution. The aided institution, like government institution, discharge public function by way of imparting education to the students. They are subject to the rules and regulation of the affiliated universities. Their activities are closely supervised by the university authorities. Employment in such universities, therefore, is not devoid of any public character. So are the service conditions of the academic staff. When the university takes a decision regarding their pay scale, it will be binding on the management. The service condition of the academic staff are therefore not purely of a private character. It has super added protection by university's decision, creating a legal right duty relationship between the staff and the management. Where there exists of this relation, mandamus cannot be refused to an aggrieved party. I'm an aggrieved party. I cannot be without any remedy, and I'm approaching a forum which is more powerful than the Supreme Court. 226 power of writ is more powerful than Supreme Court's power under 32, because Supreme Court's power under 32 is only for protection of fundamental rights. My rights, the High Court's power is fundamental and other legal rights, which can also mean rights under the common law, which is under the private law. So the fact that Tezpur Law College has been given money by the authority, the universities, in fact, pay structures, UGC guidelines are all followed. For paucity of funds, some professors may not be given, but everything is done. Why will I be denied? And especially when my suspension is only the fault that I approached the court seeking justice for my removal as secretary of the college. So I say that the maintainability.
But Mr. Das, here in this university we are concerned, in this case, not in our case, was a deemed university.
Yes, which was a private university registered under the societies.
No, but it was a deemed university by the central government under Section 3 of the UGC
Yes.
Act. Fourthly, being a deemed university, all the provisions of the UGC Act are made applicable to the respondent
Yes,
number
Lordship.
1. Now, whether that would be applicable, because if you see the UGC Act being applied, then it will come under the UGC regulations.
Yes, because the UGC, when I was appointed as principal, with UGC norms where I complied with it, I got selected as a
No,
principal.
whether in your case the UGC Act is applicable.
Well, the UGC, especially the guidelines issued under the Act is definitely
No, you have in 1998 the UGC regulations are there as to how a person can be appointed in a
Yes.
school. Now, whether
In a
or
college.
college, whether those are applicable in your case.
Yes, because the qualification stipulates all the UGC conditions. I had to get a certain qualifying marks as prescribed. So only I was eligible and
Because here there is an advertisement to that effect.
Yes.
In the advertisement, does it call for any UGC thing?
Malat,
Yes. As per the norms of the Bar Council of
Because-
India, UGC may
yes,
apply.
Malat, UGC norm is basically 55%. And I comply with it because in all law colleges throughout the SAM, whenever selections are held for teachers, the strict norms of UGC and the bar council, because professionally it's getting permission from their students come out and get a professional degree. Bar council. In fact, the JB Law College also judgment says that the JB Law College, two judgments of the Guwahati High Court was referred to.
Mr. Das, you are there tomorrow?
Yes, I have the matter here.
You are there tomorrow?
Yes.
Day after you are leaving? Huh?
Yes.
Okay. Tomorrow I'll hear you further, huh? Because I'll have a meeting out there.
Yes.
We'll take it up at 3 o'clock.
Yes, I'm ready.
The suspension matter will give it precedence.
This decision that my senior has played, this decision my senior has played is considered in St. Mary's.
Yes, and I'll distinguish it.
Mr. D.K. Das, the learned counsel, appearing on behalf of the petitioner. Mr. U.K. Nair, the learned senior counsel, assisted by Mr. M.P. Sharma, appears for the respondent. Number 5.
She for number 5.
Number 5.
You are for?
I am for, my lord, 2 and 3.
2 and 3. And Ms. S. Sharma appears on behalf of the respondent number 5. You
I am.
are?
3, 4, 3 and 4.
As per number 4.
4.
The university.
What university? One university.
On behalf of PGF.
You see, because of you are the most important person. Ask whoever it is from the Guwahati University to be present tomorrow. Because you are to say as to what will apply for them. You can't be out here just out there. I'm not going to record your name out there. None appears for the Guwahati University. So list the matter tomorrow at 3 p.m.
Lot. দেখাইছে যে গভর্নিং বডি